Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
You will bring the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Alex stole it.
Why is the dog chewing on this guy?
Now I think they've got
the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
Alex stole it
Roughing
as
him up
well.
quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case. Dahil Anglican police service watching.
Is that correct?
I didn't ask you to interrupt me.
literally not true.
Oh, from saying.
Welcome back to the Court of Public Opinion. I am the Recovery Addict. Welcome back. We're back just a couple minutes early because we have a couple things to talk about before we go to jury instructions and verdict watch in the Paul Caneiro trial. A few updates here as we've been following the Nancy Guthrie investigation. You may have seen, I think it's this picture right here, that investigators were seen carrying this box into the Guthrie home or possibly into a tent outside the Guthrie home. I always love it when some of my favorite brands are featured in crime. It looks a lot like this box right here. This is a HyperDeck Studio HD Plus, one that I've got a couple of these. They were using the Ultra Studio 4K Mini, which is almost identical. It just has a couple subtle differences. Their purpose, they can do the same thing, but what it is let me share with you just a little bit. The one they have, this Studio 4K, is actually sort of specially built to connect. This is what it looks like on the front. Well, let's not do this right now. I don't want to multitask. It's specially built to allow a lot of different inputs. So if you look on the back of this device, this is where the cool stuff is for me. This has, over here on the right, it has 2 audio channels in and audio channels out, so you can record audio through it. It has analog video, so it's got like the different the colors of analog video. It has SDI video, which is what I use and what most commercial television channels run. It also has HDMI inputs as well as Thunderbolt. So basically, any way you can get video from almost any modern device, you can put it in this machine, and it will save it basically. Let's see. Let's go back here so you guys can see what we have. So cool device. What does it mean in the Nancy Guthrie investigation? They have one of these, but a bigger version, and they just needed something on the back that has the connectors that will either connect to a computer or to a camera playback system or some sort of video storage or audio storage device, so they can record a perfect copy off that as it's being played. So you don't have to take the DVR out of the house and take it down to the crime lab and try to install it again and copy the hard drive inside. You can just connect the Blackmagic Ultra Studio MK Mini, and in between the DVR and your monitor, and then hit play, and you've got your copy. It's perfect. So, of course, RA has one. I have 3. I'm looking to get 2 more. This one is 1080p. My other 2 over here. I've got one here and one behind this computer. Those are 4K. I'm looking to get a couple more 4K ones for some stuff I'm doing. But anyway, chat, the switch has been flipped. Oh, wow, that's beautiful. That's not what I wanted. There we go. What I wanted to do was this right here and turn chat on. So why does RA need a copy from a crime scene? It's not for me. It's not for me. It's for the law enforcement, so they can have a copy that they can work with and analyze instead of just having it exist on the Guthrie's DVR, for instance. What it means, though, is that there's possibly additional information that might be able to be retrieved. And to give you a teaser about what that might be, it may be video at a higher frame rate, which means more pictures per second than what we currently have, depending on how it was exported. It's possible that we might be able to have, say for instance, instead of 10 pictures per second to make a moving video, which is sort of jerky, right? There might be 30 or 60. What does that allow? Well, it allows the space between the two pictures we do have to be stopped and analyzed, and there might be a better or a clearer shot of the suspect that can be captured from that. So this is really cool. It's really cool when tech and true crime cross paths. And I just thought I'd let you know that. So, all right. Only RA could read tea leaves based on the tech being brought in. It's really cool. It's exciting. It's the right tool for the job. I would say the wrong thing to do is what they did in the Paul Caneiro trial, which is just rip everything off the wall and then try to reassemble it at the station and hope you got all the right plugs and cables. If you remember us when you get rich and famous, if it happens, let me know. This is RA pitching for a role as an expert witness. Wow, what would I charge? What would I charge? Probably just water. If they bring Deer Park water, they've got me all day long. I mean, I already sat through 9 hours of closing testimony. I mean, I'm a patient man. Bree, I tried not to go too simple, but at the same time, you could charge $10K or a case of water. Yeah, I'd probably get the case of water. $400 an hour. That is the most I've ever charged anyone for any of my work. If you're honest about that. When drones first came out, and this was long before there was FAA licensing. When drones first came out, I was one of the first people in my state to have one. I mean, people would stop and be like, "What is that?" type of thing. That it wasn't something that the word drone wasn't a familiar term in our vernacular. And during that time, I built my own gyro-stabilized camera gimbal and figured out a way to mount a GoPro on the drone and control it from down underneath on the ground. And it was a lot of fun. It was a ton of fun, and I did get to charge $400 an hour to fly it over places and take pictures poorly, I might add. Take pictures poorly. All right. All right. Katrina Bunny. Basically, the idea is there may be video in the Nancy Guthrie home that's stored from a camera, like a security camera, that the police are getting a very good copy of. Sometimes if you shoot a video on your phone and you upload it to Instagram or YouTube or something, it will have a poor quality version. This is the way to get the best quality version of that, and it will allow just finer details to be noticed and analyzed. So good stuff. All right, Judge is coming back in right now. We're waiting for the audio to kick in, like more doorbell video or more security camera video. Oh, Kim R16 won the internet and first in stream. Congratulations, Greeners. Thank you very much for reminding me. I forgot about that. Kim won with this comment. She said, "Joe," which I think in Spanish means yo, with J being a Y sound. So, Kim, congratulations. You were first in chat. Greeners says, "You got my first buffer." You'll never forget your first, Greeners. And wonderful. Kim wins always. I think Greeners was actually first and then said not it. So Kim won. Anyway, we're starting court, and the good news if you're here is that the closings are over. The closings are over. We're now waiting for the judge to give what will feel like a relatively quick instruction, even if it takes 45 minutes, to the jury regarding the charges, the law that they need to follow when deliberating in this case. And we promised before that we were going to do a poll, one more poll, and we'll do it again. Even though the closings are not evidence, we're gonna do a guilt and innocence poll. Is Paul Caneiro? Let's see if I can get this right. Maybe I need to spell his name right as well. I think it's E-I. Guilty. As charged. And by as charged, I'm going to include the idea that if you think he committed murder, the answer would be yes. As always, the first answer is no. So read carefully, choose carefully. Don't click in haste. The poll is going up in just a moment. So if you're clicking around on the chat window, you might accidentally answer a poll in just a second. So hands off your mouse for a minute. There we go. Here comes the poll. Poll's up. All right. Vote your conscience as you would if you were a juror in this case. And we saw all the evidence. You did. You saw all the evidence. Next poll, who was more boring, defense or prosecution? Man, that's a tough one. Because there's the whole, you know the idea behind what have you done for me lately? It's the most recent memory is the one that sticks out so prominently. So defense for me is is a distant, hazy memory compared to the torture we sat through with prosecution this morning. I think all in all, though, I'd have to say that defense did a better job with theirs the prosecution did a better job than the defense did. How many Part 19s? We have 3 Part 19s on the thumbnails dating back to yesterday and Part 20 this morning. Okay. Did I mention, Josh, that math is not my strong suit? Once we get past 10, counting becomes more difficult. I might have to renumber them. The problem is I copy the previous one, and sometimes I forget to update the number. So, all right. Let's see. We have a confession. Click the wrong one. Okay. All right. We'll sway the numbers one the other direction. It doesn't matter. No one is going back to watch these closings. Do a poll to see how many of us hit the wrong choice in the previous poll. There would be an inherent problem with that poll because there's a good chance the people who hit the wrong one in that one would hit the wrong one in this one as well. I found out they both recapped the whole dang trial. The jurors aren't allowed to take notes. Right. That's what we were talking about. The jurors, only the judge was taking notes, and of course the lawyers. I always put no on the poll first. That is tradition because there's a presumption of innocence when you're charged. So we start with no. 3 people so far hit the wrong button. Thank you, Virginia. I saw 2 people say they hit the wrong one. I hit the wrong thing, guilty. Okay, so basically what this means is with the number of votes we have so far, we're pretty much all on the same page. Only about 320 votes in, 8% of you say no, which could either mean not proven or not guilty. Let's see.
Bring the jury.
Oh man, terrible days. Copy paste was amazing. What time did the prosecutor finally stop talking? As far as times, I'm not sure, but it was 5 hours 25 minutes, I think, by my counter. Defense had used 3 hours and 30 minutes the previous day, but the prosecutor was stretched over 2 days, so he did 2.5 hours one day and basically the same the next, and plus a little. Okay. I think tomorrow's sentencing for Juliana. This is the au pair. We are going to try to cover that if we get access. We're working on that. That'll be interesting because I believe it's the same judge that handled the main trial that will be doing the sentencing for Juliana. And there's a plea deal obviously in the works, and we'll just see if the judge accepts that plea deal and holds to it, and what it's. She could deviate. Well, I don't think she will, but she could. How are these closings not cruel and unusual? Apparently in New Jersey, this is business as usual right here. AWOL says, I'm leaning towards guilty, but I still have questions. But are they reasonable doubt? Do you doubt that he did it? And is that doubt reasonable? Has the jury gotten their judge instructions? No, Big Sky, we're about to hear that. And I think the most important part for me is not necessarily the letter of the law and the elements of the charge, although that's very crucial for this case and for the jury to understand. I believe the elements of the crime have been met, as at least evidence has been put forward to meet those elements of the crime, of the charges. the part I want to hear is how the judge instructs the jury about what they should do in deliberations first, what they do when they first walk in that door. Is there any instruction whatsoever about how long they should take or how thorough they should be re-looking at evidence? We know that they don't have any notes to go over, so that will, I guess, save time or take more time as they have to re-look at evidence. But there's a lot of evidence going back there with them. We might need mugs to say we survived the great closings of 2026. Blair, talking about the au pair case, says, I think this plea deal is BS. And I hate to say it, but I know she would not get the kind of plea deal if she was American, but at the same time, it's better for our tax dollars if she goes home. I don't know about the last part, because we have seen some sweet plea deals for Americans. I don't think it's a racial situation. I think that the deal sort of reflects the desperation the prosecution was under. Look at how much time had passed. They were trying to get a break in the case, and she wasn't talking, and they basically had to sweeten the pot until she did. So I think that's what it is. Let's see, anything else? It's snowing at the half pipe. How are the Olympics going? How is your favorite team and or country doing? I know sometimes I like to cheer for. I don't just cheer for my own personal country. Obviously, I've got family connections in multiple countries, friend connections, and even more. So love watching the Canadians do well. Love watching the Brits do well. Love watching the Norwegians do well, and Sweden, and everything else. And then occasionally you get one of these little countries that's like, have they ever seen snow? Like the Jamaica incident from True Cool Runnings. And watching them compete in the winter sports is great as well. So, knitting with me. Oh my goodness! You need to get over that real quick. Don't let that hang around. If you have any input whatsoever, make sure it's a short stay. If you got pneumonia, have to root for Norwegian and Swedish cousins. Clever name says, for me, there's only America. Yeah, it's a lot of fun. I love the Olympics and watching teams do well, and individuals just achieve a personal best or a world record or something else. According to the movie, snow is not required for training. I want Jamaica to win the bobsled event this year. Cool Runnings 2.0. Aaron Blackman says, RA, this may be late news, but did you see the Supreme Court reverse the judgment in the Maya trial citing judicial error, I believe? We did. This is almost all of it gets thrown back and basically start over from scratch. There'll either be a new trial or what's most likely the case, this is my personal opinion, there will be a settlement, and the settlement will be much smaller than original because all the parts that were thrown out were pretty bad. But I can see a settlement in the, I don't know, $5 to $15 million range, as offered by the hospital. And I realize that's just a fraction of what was awarded, but it was all thrown out. And when they redo it, a lot of that can't come back in. Some of it was double dipping. Some of it was the Supreme Court basically said you can't prove that, you can't use that in this way. And so the evidence or the testimony about her mom taking her own life because of the treatment basically won't be in the next trial if it goes forward. And I think that was a powerful factor in driving up that verdict amount. All right, Lindsey Vonn, I believe she broke her leg on a downhill run. She was flown off the mountain in a helicopter. Sorry, I didn't mean to spoil that if you haven't watched the Olympics yet. All right, waiting for the court to start. We're about 2 minutes late right now. I'd be surprised if Lindsey Vonn returns to skiing. That might be she might be done, right? And that's sad to end that way, but she's had a really good run. So you don't wish a skier to break a leg before their big race? No, nor do you wish the skier to straddle a gate, which I'm not sure if that happened this year or before. I saw a Frenchman miss a gate on the downhill and sort of split the distance, so to speak. And I felt the pain. I felt the pain just in watching it. Also, while we're on the topic, man, there's a video of curling from I don't know when, like 1960s or something, with the guy who's throwing the stone. He's got a cigarette in his mouth, and he slips and falls, kicks the rock. It's just amazing. I'll have to see if I can find that. They showed that online yesterday. Oh, yes, the painful one. Oh, my goodness. I feel bad for Lindsey Vonn. I feel bad that she's hurt, but basically these Olympic athletes are operating at such a high level that they're pushing their bodies to the limit. And it literally is expected that they only have a short duration of time where they can perform at that level before their body breaks. Okay? They are literally pushing the human body to levels that it's not designed to function at, and so it's a matter of time. It's incredible skill, but I think she's had a really good run, but I think it's over now. Curling accidents are the worst. Pinch fingers between stones. Can you imagine? Oh my goodness. I like watching curling. One of my favorite sports. The agony of defeat. Oh, man, that quote is amazing. All right. I had a good lunch. I had leftovers, by the way. My wife had made some food for neighbor family. Gentleman's not doing well. And she made enough for us to have some as well. So yesterday it was like angel hair spaghetti noodles with it's like I would say it's chicken Alfredo, but it was a very, it was almost like a garlic-based, very Italian feel to the sauce with of course, chicken in it as well. It's really yummy. My wife and I split the leftovers, and now it's gone. Talking about Shaun White, like is that the Carrot Top guy? The orange hair, the flaming orange hair, like it looks. I guess it's red hair, but chicken primavera. That might have been it. Let's see. I cringe when people say noodles. You don't like noodles? Flying Tomato. That's him. Surgery tomorrow on a broken wrist after falling in my new yard. Oh, no. Who's flipping pancakes? No, I'm sorry, Tammy. First of all, I hope your wrist gets better. And now on secondary, who's going to flip the pancakes at your house? Is your husband up for this? I hope you get feeling better. I'm so sorry you fell. That's no fun. Don't listen. All right. Thank you, Greeners. All right, we're delayed on the return. We're 6 minutes late with basically no reason. And why I say no reason is it's just the judge left. It's just his instructions. The jury instructions are all that we have left to do. Aaron Blackman says, RA and mods, thanks for all you do. Currently in Bahrain for the next year, and this channel makes me feel connected to back home. Love the community. Wow. I would ask what you're doing in Bahrain, but I think if you told me, you'd have to kill me. So I hope you have fun, Aaron. Enjoy. Be safe. And thank you for joining, and obviously thank you for supporting the channel. It means a ton. It's my left arm. I'm right-handed. Whew. Okay. Thank you. So your husband will mix the pancake batter, and you will still flip the pancakes. That's important. Time has stopped for the court. Time keeps on ticking into the future. As soon as the judge finishes his instructions to the jury, we're going to do a poll on the jury deliberation. Aaron also coming in with 5 gifted memberships. Thank you, Aaron. Extremely generous. Appreciate you. Longtime supporter of the channel there. think you are, in fact, an OG. Maybe the jury made a break for it after those closings. They might be out in the hallway fighting over who gets to be the alternate. Wogger, thanks for the update. Sean and Nina are a thing no more. Broke off their engagement. Colleen, how are you doing? Hope you're doing well. Hope your horses are doing well now that the storms are past. I guess there might be more coming your way, right? I'm not sure exactly where you're located, but I'm ambidextrous. I can mess things up with both hands. That is a skill. Aaron's just hitting all the buttons he possibly can. We've got super chats, gifted memberships, and membership renewal messages all coming in at the same time. Thank you. And Lily Bomb says, thank you. I finally got one, thanks to Aaron. Are we watching the au pair? We're going to try to Northwest. I'd like to sort of put a bow on that trial, and that would do it, with the exception of, I think, sentencing. That's going to be a little while out, but there's a hearing on Karen Reed today. I'm following that loosely, obviously not directly. Let me actually look and see if I've got an email regarding that.
Hush! Now I'm trying to have court. Don't raise your voice.
Didn't check my email yesterday. Got a couple Nancy Guthrie's updates.
Even a blind squirrel finds a nut every once in a while.
In front of the Walmart.
I ended the last stream a little abruptly because I ran out of time, but I did want to recap and just hit one more time. I watched the video. I'm not going to link her channel because I can't find it again, honestly. I subscribed to her and then it went away. But there's a young woman that that is in a wheelchair, has degenerative disease. She has CP, and she had been working with physical therapists to be able to walk, and she was using, one of those walkers, the 4-posted walkers.
Even a blind squirrel finds a nut every once in a while.
She was doing everything she could, but she had been falling and being injured, and that was making things worse, obviously. She had just received news from her doctor.
You don't put a diplomatic plate on a hoopty.
That she would not be able to walk again. Like, you can't do that anymore. Basically killing her dreams of being able to walk as someone who's, for the most part of her life, confined to a wheelchair. And she was obviously crushed by that. And her reaction was just authentic. She was asking for, prayers as she tries to come to grips with that reality as something she's been working for, being gone. But what she said next just changed my perspective on life in a moment. And she shared how grateful she was that in the few steps that she was able to take with her friend. And just how grateful it came across, just how grateful she was that she was able to take these halting steps with the walker by the side of her friend. And wow, how grateful she was. And then I'm looking at my life thinking, here I am thinking, oh, I don't want to get up right now. I'm too tired. Somebody go get me some water. I'm perfectly able-bodied and, don't think twice about limitations other people deal with constantly. So I've tried to be a little more grateful in my life, and I'm gonna continue to do that. I'm also gonna try to keep sharing inspirational stories I see from people online with you all, because I think that's something that will be good for all of us. Out and About with Di says, what a morning, waking up to RA Live, and Australia won a medal finally. Awesome. Aussie. Oi. I'm happy for them. And by the way, Di, OG, 29 months of support. Thank you very much. I really appreciate that. All right. Unless Paul is taking a plea deal, I don't understand what the delay is. This does not make sense. Oh, man. That's awesome, Bree. That is really cool. Thumbnail says part 19. This is part 21. I'm going to rename this one to 21 because looks like we might have some action here. There we go. There we go. Things are happening. Things are moving and shaking. Rosie's overruled. Love the channel chat. Appreciate all the wonderful work. Thank you. 13 months. And also maybe Megan, maybe not, comes in with a 33-month membership milestone. Favorite corner of the internet. Best host mods in chat. You're all loved. Y'all are loved. Megan, thank you very much. Appreciate your support. It wouldn't be the same without you here. Also, Jay McCarthy World. Gratefulness and mindfulness has become a huge part of my life. Reframing my brain and positive psychology changed me. It definitely makes me think twice about complaining about anything that I'm dealing with. Anything. So thank you very much. That is very, very true. I'm working on doing that same thing now. All right. With that, we had some motion, and then he left again. We don't know why. Let me do a quick little check and make sure we have everything as current as we possibly can get it. And we do. So. All right. Megan. You are, in fact, an OG. There we go. There you go. You're an OG. I'm sorry I missed you there. 33 months. You definitely qualify for that. And Greeners gave you one as well, which might have been his first. You remember that one too, Greeners? Your first OG. The grass is greener on the other side. Could it be the gardener, the water, the fertilizer, or the AstroTurf? You'll only know when you hop the fence. Joe brings up a great point. We did, right before break, have an objection by the defense. Not an objection. They approached and talked sidebar, which I believe is an objection. There's nothing else that the defense really has to do at this point. So any reason to approach would be an objection. So I'm calling it that way. Betty wants the plea now. If you were the state, because they don't have to keep the plea out, I don't think. If you were the state, and at this point in the trial, Paul's lawyer came to you and said, we'd like to talk to you about a plea offer right here, 11th hour. What do you say? Are you confident enough in your case that you would let's say, no, let's let 12 people decide? Or do you take the definite win with probably a lesser sentence? Larly Annie, I'm just a toddler still, but I've been watching way longer. Happy birthday, Scott. It's not my real birthday. It was just a pancake day. But Larly Annie, thank you very much. I should have posted a little clearer that I was, the advice I was taking this morning when I posted a picture of me eating pancakes at IHOP was just to go to IHOP and get pancakes. It was not to go there and get free pancakes on your birthday. That was my fault. I should make that more clear. You are allowed to have an off day every now and then and be grumpy. No need to be positive when life sucks sometimes. Just don't say sour afterwards. There are ups and downs. I mean, if we didn't know pain, would we know joy? Right? How can you tell the difference if you don't know what one is? State would take a 30-year plea. He won't live that long. Here we go. Waiting for audio. Waiting for audio. He's saying, come up, come up, come up. He hasn't taken the bench yet, which is officially when... Oh. He leaves the judicial door open. Goes back into his office. I think he forgot something. I think he'll be right back out. This is me when I think like Calvin on a sled in Calvin and Hobbes. All right, here we go. He is right back out. I told you he just forgot something. Let's go here. Just waiting. Let's go the other place. Stop this one. Judge is cleaning his glasses. If anyone knows what his coffee mug said this morning, I'd love to find out what it was. Not the first one. The first one was just a black mug. The second one, the white with black letters, I'd love to know what that was. Do tell. Okay. Looks like we're going to be coming back here in just a second. Still no audio, but everyone's standing, means the jury might be coming in. Green blazer. Did she change? Is she doing midday swaps? Getting through the whole fashion? Maybe she's sponsored by a fashion company and she has to wear, 2 suits a day. Could be. Does she have a hand warmer? It might be very cold in the courtroom. Looks like they're all smiling, trying to be personable for the jury. Just waiting for the judge now to turn on the mics. Anybody else we're waiting for? Bailiff says, hey, come sit down, you're fine. People are filing in. Paul does a rare backward glance to see who's supporting him on his side. A lot of empty pews back there. Little wave from behind the bailiff. And a smile from Paul. We don't get many of those. Still waiting for audio. I don't know who that was. I'm not sure. Is this verdict? No, this is jury instruction. So this would be the kicking off the verdict watch. I door-dashed $100 worth of IHOP one night after my husband and I had a night out and the dasher stole it. I waited so long to finally get it. It was so disappointing. Oh no. Lizzie, I'm not sure if I'm taking your word on it that if that's his wife and she's there supporting him.
Okay, ladies and gentlemen, we've come to that point where we've heard all of the summations. You're now going to hear the law from me. First thing I'm going to do is I'm going to tell you that I'm going to violate every rule of public speaking right now because I'm going to read. So I apologize to you for that. The second thing I'm going to apologize for is that I'm going to change my glasses because these glasses are better for me to see and look at you at the same time. I'm not trying to look different, but you can tell me if I look smarter. Here, let's see.
We do have an audio
No.
listener.
Still the same, huh? Just the same. All right.
Shots fired.
All right. Ladies and gentlemen of the jury, the evidence in this case has been presented and the attorneys have completed their summations. We now arrive at the time when you, as jurors, are to perform your final function in this case. At the outset, let me express my thanks and appreciations to you for your attention to this case. I would like to commend the counsel for their professional manner in which they have presented their respective cases and for their courtesy to the court and jury during the course of the trial. Before you retire to deliberate and reach your verdict, it is my obligation to instruct you as to the principles of law applicable to this case. You shall consider my instructions in their entirety and not pick out any particular instruction and overemphasize it. Generally speaking, these instructions consist of 4 parts. The first part deals with the general principles of law that apply in a criminal case. The second part describes the evidence that you may consider in your deliberations. The third part is about the portions of the Criminal Code of New Jersey that must apply to the facts you find in this case to determine whether the state has proven beyond a reasonable doubt that the defendant violated a specific criminal statute. Finally, the fourth part of the instructions tells you how to go about conducting your deliberations. You must accept and apply this law for this case as I give it to you in this charge. Any ideas you have of what the law is or what the law should be, or any statements made by the attorneys as to what the law may be, must be disregarded by you if it's not consistent with my charge here today. Now, beginning with the general principles of law that apply to a criminal case,
I'm going to try to fix
Defendant Paul Caneiro stands before you on an indictment returned by the grand jury, charging him with 4 counts of murder.
Hold, please.
2 counts of felony murder, 2 counts of aggravated arson, 2 counts of a possession of a weapon for unlawful purpose, 1 count of unlawful possession of a weapon, 1 count of theft of movable property, 1 count of misapplication of entrusted property, and 2 counts of hindering apprehension of oneself.
That's a lot of charges.
The indictment is not evidence of the defendant's guilt on these charges. An indictment is a step in the procedure to bring this matter before the court and the jury for the jury's ultimate determination as to whether the defendant is guilty or not guilty of these charges. The defendant has pled not guilty to these charges. The defendant on trial is presumed to be innocent, and unless and until each and every essential element of the offense charge is proven beyond a reasonable doubt, the defendant must be found not guilty of that charge. The state has the burden of proving the defendant guilty beyond a reasonable doubt, and that burden never shifts to the defendant. The defendant in a criminal case has no obligation or duty to prove his innocence or offer any proof relating to his innocence. I should stop right there for a minute. As you've heard, a defendant does not have to talk to the police at all. If he does decide to talk to the police, he can. But if he doesn't, then you cannot hold it against him in any regard. Understand?
Yes.
All right. The prosecution must prove its case by more than a mere preponderance of the evidence, yet not necessarily to an absolute certainty. The state has the burden of proving the defendant's guilt beyond a reasonable doubt. You've heard the attorneys talk about what reasonable doubt means. I'm going to tell you what it means right now. Some of you have served as jurors in civil cases where you were told that it is necessary to prove only that a fact is more likely true than not true. In criminal cases, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. A reasonable doubt is an honest and reasonable uncertainty in your minds about the guilt of the defendant after you have given full and impartial consideration to all of the evidence. A reasonable doubt may arise from the evidence itself or from a lack of evidence. It is a doubt that a reasonable person hearing the same evidence would have. Proof beyond a reasonable doubt, for example, leaves you firmly convinced of the defendant's guilt. In this world, we know very few things with absolute certainty. It is not the state's job to prove this case beyond any and all possible doubt. If you are firmly convinced of the defendant's guilt on a particular charge, you would find him guilty of that charge.
Synced it up.
If you are not firmly convinced of the defendant's guilt as it relates to a particular charge, you would find him not guilty. The function of the judge is separate and distinct from the function of the jury. It is my responsibility to determine all questions of law arising during trial and to instruct the jury as to the law which applies in this case. You must accept the law as given to you by me and apply it to the facts as you find them to be. During the course of the trial, I was required to make certain rulings on the admissibility of the evidence, either in or outside of your presence. These rulings involved questions of law. The comments of the attorneys on these matters were not evidence. In ruling, I have decided questions of law, and whatever the ruling may have been in a particular instance, you should understand that it is not an expression or an opinion by me on the merits of the case. Neither should my other rulings on any other aspect of the trial should be taken as favoring one side or the other. Each matter was decided on its own merits. During the course of this trial, there were numerous occasions during which the court conferred with attorneys at sidebar. These conversations are a normal and necessary part of trials and are designed to address various legal, procedural, and evidential issues that arise during the trial. You must not speculate about the subject matter of any sidebar conference, nor should you draw any inference or conclusion from the fact that sidebar occurred. Neither should my rulings that result from these conferences be taken as favoring one side or another. Additionally, you must not consider or evaluate the communication between the court and the attorneys during sidebar conferences for any purpose. Judicial dialogue during legal discussions are not evidence and are not an indication of how the court views the attorneys, the facts of the case, the credibility of the witness or witnesses, or the guilt or innocence of the defendant. It is also important to note that attorneys in this case are tasked with providing zealous advocacy, which includes raising objections, making legal arguments, and addressing issues at sidebar. I may have sustained objections to some questions asked by counsel, which may have contained statements of certain facts. The mere fact that an attorney asks a question and inserts facts or comments or opinions in that question in no way proves the existence of that fact or facts. You will only consider such facts which, in your judgment, has been proven by the testimony of the witnesses or from the exhibits admitted into evidence by the court. The fact that I may have asked questions of a witness in a case must not influence you in any way in your deliberations. The fact that I asked such questions does not indicate that I hold any opinion one way or another as to the testimony given by the witness. Any remarks made by me to counsel or counsel to me or between counsel are not evidence and should not affect or play any part in your deliberations. As I instructed you in the beginning, I indicated that you are the judges of the facts. And as the judges of the facts, you are to determine the credibility of the various witnesses as well as the weight to be attached to their testimony. You and you alone are the sole and exclusive judges of the evidence, of the credibility of the witnesses, and the weight to be attached to the testimony of each witness. Regardless of what counsel said, or I may say, recalling the evidence in this case, it is your recollection that controls as it relates to the evidence and how you're going to apply such evidence. Arguments, statements, remarks, openings, and summations of counsel are not evidence and must not be treated as evidence. Although the attorneys may have pointed out what they feel was important in this case, you must rely solely upon your understanding and recollection of the evidence that was admitted during the trial. You saw 2 PowerPoints during the course of the summations. I just want to remind you there was testimony that was relayed in those PowerPoint slides. It is for you to decide if that information that was supplied to you on those PowerPoint slides reconciles with your recollection of what the testimony was. If for some reason that when you are reading it on the screen for either side and you decide, that's not the way I remember it, it's the way you remember it that matters. It's not the way that you saw it on a particular screen. Whether it's spoken on a screen, or noted on a screen or spoken in words, always it's your recollection that controls when we deal with the evidence. It is your sworn duty to arrive at a just conclusion after considering all the evidence which was presented during the course of the trial. Now I will move on to part 2 of the instructions and discuss the evidence that you may consider in judging the facts of the case. When I use the term evidence, I mean the testimony you have heard and seen from this witness box, right there, any stipulations and the exhibits that may have been admitted into evidence. Any exhibit that has not been admitted into evidence cannot be given to you in the jury room, even though it may have been marked for identification. Only the items that were marked into evidence can be given to you. If you remember, we had this discussion a day or two ago. You can always remember the testimony about an exhibit, but if you don't have it, I promise you, we gave you everything you're supposed to have. If you don't have it, you can only rely on the testimony about that exhibit. You are instructed that certain photographs have been admitted into evidence as exhibits for both the state and the defense. The duplication of any photograph does not increase or decrease its evidential value. You must not give it greater or lesser weight to any exhibit because it appears more than once. All evidence is to be considered and evaluated by you under the same standards. Any testimony that I may have had the occasion to strike is not evidence. It shall not enter into your final deliberations. Remember the number 2 pencil with the eraser on it. It must be disregarded by you. This means that even though you may remember the testimony, you are not to use it in your discussions or deliberations. Further, if I gave you a limiting instruction on how to use certain evidence, that evidence must be considered by you for that purpose only. You cannot use it for any other purpose. As jurors, it is your duty to weigh the evidence calmly, without passion, prejudice, or sympathy. Any influence caused by these emotions has the potential to deprive both the state of New Jersey and the defendant of what you promised them: a fair and impartial trial by fair and impartial jurors. Also, speculation, conjecture, and any other forms of guessing plays no role in the performance of your duties. As jurors, your oath requires that you not be affected or influenced by any personal likes or dislikes, opinions, prejudices, sympathy, or biases, including implicit or unconscious bias. During your deliberations, if you think unconscious bias is affecting your evaluation, think about the evidence again with the video and this instruction in mind. Remember in the beginning when we started 110 years ago where we watched that video about bias? We watched it downstairs. Yes. If for some reason during the course of your deliberations when you're in the room, if you start thinking a certain way and you're like, wait a minute, I'm starting to think in a way I was told not to, take a step back, reevaluate the way that you're thinking, and make sure you leave all of that type of unconscious bias to the side, okay? All right. As I instructed you at the beginning of the case, evidence may either be direct or circumstantial. Direct evidence means evidence that proves a fact without an inference and which, if true, conclusively establishes that fact. On the other hand, circumstantial evidence means evidence that proves a fact from which an inference of the existence of another fact may be drawn. An inference is a deduction of fact that may logically and reasonably be drawn from another fact or group of facts established by the evidence. Whether or not inferences should be drawn is for you to decide using your own common sense, knowledge, and everyday experience. Ask yourselves, is it more probable, logical, and reasonable? We don't ask you when you come in here and be jurors for this case, we do not ask you to leave your common sense at the door. We want you to bring it in. We want you to use it as a part of your deliberations. It is not necessary that all facts be proven by direct evidence. They may be proven by direct evidence, circumstantial evidence, or a combination of direct and circumstantial evidence. All are acceptable as a means of proof. In many cases, circumstantial evidence may be more certain, satisfying, and persuasive than direct evidence. However, direct and circumstantial evidence should be scrutinized and evaluated carefully. A verdict of guilty may be based on direct evidence alone, circumstantial evidence alone, or a combination of direct and circumstantial evidence, provided, of course, that it convinces you of the defendant's guilt beyond a reasonable doubt. The reverse is also true. A defendant may be found not guilty by reason of direct evidence, circumstantial evidence, or a combination of the two, or a lack of evidence, if it raises in your mind a reasonable doubt as to the defendant's guilt. The parties have agreed to certain facts. The jury should treat these facts as undisputed, meaning that the parties agree that these facts are true. As with all evidence, undisputed facts can be accepted or rejected by the jury in reaching a verdict. The stipulated facts are as follows. During the testimony of Lieutenant Petrozzillo, you heard on January 27, 2019, a recorded phone call during which Paul Caneiro and his wife, Susan Caneiro, discussed whether Susan can use her existing power of attorney to access the TD Bank trust account. It should be clarified that the parties stipulate that prior to this call, on December 3, 2018, Paul Caneiro resigned as trustee of the Keith Caneiro Irrevocable Trust and did so via Susan's power of attorney. As a result, the role of trustee was transferred to Corey Caneiro. Second stipulated fact is that Jesse Caneiro had an iPad. The parties agree that Jesse Caneiro's iPad was never seized or searched by the police. Now, as the judges of the facts, you are to determine the credibility of the witnesses, and in determining whether a witness is worthy of belief and therefore credible, you may take into consideration the following: the appearance and demeanor of the witness, the manner in which he or she may have testified, the witness's interest in the outcome of the trial, if any, his or her means of obtaining knowledge of the facts, the witness's power of discernment, meaning his or her judgment and understanding, his or her ability to reason, observe, recollect, and relate, the possible bias, if any, in favor of the state for whom the witness testified, the extent to which, if at all, each witness is either corroborated or contradicted, supported or discredited by other evidence, whether the witness testified with an intent to deceive you, the reasonableness or unreasonableness of the testimony of the witness has given, whether the witness made an inconsistent or contradictory statement, and any and all other matters in which the evidence will serve to support or discredit his or her testimony. Through this analysis, as judges of the facts, you weigh the testimony of each witness and then determine the weight to be given to it. Through the process, you may accept all of it, a portion of it, or none of it. Now, the burden of proving the identity of the person who committed the crimes is upon the state. For you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant is the person who committed the crime or crimes. The defendant, Paul Caneiro, as a part of his general denial of guilt, contends that the state has not presented sufficient reliable evidence to establish beyond a reasonable doubt that he is the person who committed the alleged offenses. The defendant has neither the burden nor the duty to show that a crime, if committed, was committed by someone else, or to prove the identity of that other person. You must determine, therefore, not only whether the state has proven each and every element of the offenses charged beyond a reasonable doubt, but also whether the state has proven beyond a reasonable doubt that this defendant is the person who committed it. Now we're going to see who's paying attention. See if you've heard this before. As a general rule, witnesses can only testify as to facts known by them. This rule ordinarily does not permit the opinion of a witness to be received as evidence. However, an exception to this rule exists in the case of an expert witness who may give their opinion as to any matter in which they are versed, which is material to the case. In legal terminology, an expert witness is a witness who has some special knowledge, skill, experience, or training that is not possessed by the ordinary juror, and who thus may be able to provide assistance to the jury in understanding the evidence presented and determine the facts in this case. In this case, the state and defendant both called experts. Danielle Reed, Christine Schlanker, Christopher Simkovac, Teresa Nizidzan, brutal, in the field of forensic DNA analysis, Allison Lane in the field of forensic serology, biological stain identification, Detective Deborah Bassender in the field of forensic accounting, Dr. Lauren Toma and Dr. Alex Zhang in the field of forensic pathology, Judith Link in the field of gunshot residue, Detective Sergeant Christopher Clayton in the field of firearm and tool mark identification, Detective Joseph Cardoma in the fields of bloodstain pattern analysis and fire investigation, origin and cause determinations, Michael Abraham in the field of electrical and electromechanical matters, including cause and origin of fires and explosives, John Lightbody in the field of fire investigation, origin and cause determination, Lazaro Cardenas in the field of trust and estate law, and Carl Reich in the field of forensic DNA analysis. Just think that's how many times I've read that charge to you in the past. You are not bound by such expert opinion, but you should consider each opinion and give it the weight to which you deem it is entitled, whether that be great or slight, or you may reject it. In examining each opinion, you may consider the reasons given for it, if any, and you may also consider the qualifications and credibility of the expert. It is always within the special function of the jury to determine whether the facts on which the answer or testimony of an expert is based actually exist. The value or weight of the opinion of the expert is dependent upon and is no stronger than the facts on which it is based. In other words, the probative value of the opinion will depend upon whether from all of the evidence in the case you find that those facts are true. You may in fact determine from the evidence in the case that the facts that form the basis of the opinion are true, not true, or true in only part. And in light of such findings, you should decide what effect such determination has upon the weight to be given to the opinion of the expert. Your acceptance or rejection of the expert opinion will depend, therefore, to some extent on your findings as to the truth of the facts relied upon. You and you alone are the sole fact finders in this case. You must be persuaded solely by the evidence presented at trial when determining whether the state has satisfied its burden. As the sole judges of the facts, you are to determine the credibility of the various witnesses as well as the weight to be afforded to their testimony to determine whether the state has proven beyond a reasonable doubt all elements of the crimes charged. The ultimate determination of whether or not the state has proven defendant's guilt beyond a reasonable doubt is to be made by you alone. There is for your consideration recorded and unrecorded oral statements allegedly made by the defendant. It is your function to determine whether the statements made It is your function to determine whether the statements were actually made by the defendant, and if made, whether the statements or any portions of them are credible. In considering whether or not an unrecorded oral statement was actually made by the defendant, and if made, whether it is credible, you should receive, weigh, and consider the evidence with caution based on the generally recognized risk of misunderstanding by the hearer or the ability of the hearer to recall accurately the words used by the defendant. Aside from the risk of fabrication, verbal admissions can be unreliable because experience shows that they are frequently misunderstood, imperfectly remembered, and inadvertently made. The specific words used and the ability to remember them are important to the correct understanding of any oral communication, because the presence or absence or change of a single word may substantially change the true meaning of even the shortest sentence. In this case, it is alleged that the defendant made unrecorded statements to Fire Marshal Craig Flanagan, Detective Brian Weisbrot, and Detective Christopher Brady. You also heard statements recorded by the body-worn cameras of Patrolman David Marino, Patrolman Brendan Bernard, and Patrolman Charles Winkowski. In considering whether these statements are credible, you should take into consideration the circumstances and facts as to how the statements were made, as well as all other evidence in this case relating to this issue. If, after consideration of all these factors, you determine the statements were not actually made, or the statements are not credible, then you must disregard them completely. If you find the statements were made, and that part or all of the statements are credible, you must give what weight you think appropriate to the portion of the statements you find to be truthful and credible. You are also presented with a video during the trial. It's always within the special function of the jury to determine the facts. This includes what is or is not depicted on a video, and what significance, if any, that it has. In this case, Detective Ryan Mahoney, Brian Weisbrot, and Lieutenant Patrick Petruzillo narrated a video for you. Detective Mahoney, Captain Weisbrot, and Lieutenant Petruzillo are not eyewitnesses to the events depicted on the video and did not observe the events as they happened. Rather, the witnesses' testimony is based on their viewing of the video after the incident occurred. This testimony was permitted only for the limited purpose of, 1, providing context for the video, such as the location of the recorded events and or the location and or angle of the camera that made the recording, and or 2, explaining the length of the video, whether redactions were made, and or when it will be fast forwarded, and or 3, focusing your attention to a specific individual action and or circumstance allegedly depicted in the video. Do me a favor, just look, make sure it's number 4. Mine good. Okay. It says number 5 on my sheet, but it's actually number 4. Sorry, I'll fix that. For the limited purpose of drawing the juror's attention to certain parts of or objects depicted in the video, and to therefore aid in your review of the evidence. You may not consider Detective Mahoney, Captain Weisbrot, and Lieutenant Petruzillo's narration or other comments on the video for any other purpose. The narrating witness's testimony may assist you in deciding what the video shows. However, you are not bound by the narrating witness's testimony, and you may reject any narration testimony. You should consider each opinion and give it the weight to which you deem it is entitled, whether it be great, slight, or none at all. Ultimately, it is up to you and you alone to decide for yourself what the video shows and what it does not show. It is also up to you to determine how much weight to give the video evidence. In other words, it is the role of the jury to decide the significance and import of the video, as well as anything shown in the video. I also remind you that the ultimate determination of whether the state has proven defendant's guilt beyond a reasonable doubt is to be made by you alone. Now, during the trial, you heard 3 phone calls November 2018 to February 2019, which indicate that as of those dates, the defendant, Paul Caneiro, was arrested and incarcerated. The fact that the defendant was arrested and incarcerated for any period of time should not enter into your discussions or deliberations in any manner at any time. Arrest, indictment, and incarceration are not evidence of guilt, but rather a part of the pretrial procedure that occurs prior to the matter coming before you to determine whether the defendant is guilty or not guilty of the crimes charged. As I remind you, the defendant is presumed innocent, and the burden of proving each element of the charge and charges beyond a reasonable doubt rests upon the state, and that burden never shifts to the defendant. Only you, as members of the jury, will decide whether the state has met his burden. You have heard testimony that the defendant, Paul Caneiro, lawfully owned a collection of various firearms, fire accessories, and training items within his home at 27 Tilton Drive in Ocean Township. This evidence is being offered for a very limited purpose. You may consider it insofar as it may relate to the defendant's ability to carry out these alleged crimes, i.e., that he had the means and/or opportunity to commit the charged offenses. Or, if you do not find that this evidence to be relevant, you may then disregard it. You may not use this evidence for any other purpose, such as to conclude that the defendant has a bad character or that he has a propensity to commit violent crimes. You may not use this evidence to convict the defendant simply because he owned weapons or because you may personally disapprove of individuals who lawfully possess firearms. While the defendant lawfully possesses these firearms, training items, and related accessories in his home, the state alleges that the defendant unlawfully possessed a handgun outside of his home, specifically at 15 Willowbrook in Colts Neck, New Jersey. The state further alleges that the defendant possessed this handgun with the purpose to use it unlawfully against others. As you have heard, the state bears the burden of proving each element of the crimes charged beyond a reasonable doubt. You, as members of the jury, will decide whether the state has met that burden. You have heard testimony from, from prosecutors Decker and Wallace, Lieutenant Petrozzillo, and Captain Weisbrot speaking to a witness about the case at some point prior to coming to testify at trial. The law permits prosecutors and detectives to speak to a witness about a case before the witness testifies, and it permits assistant prosecutors and detectives to review with the witness the questions that may be asked at trial, including questions that may be asked on cross-examination. Speaking to a witness about their testimony is a normal part of preparing for trial. It is not improper as long as there is no suggestion made to the witness that the witness depart from the truth. You have also heard testimony that a witness read or reviewed certain materials pertaining to this case before the witness testified at trial. The law permits a witness to review certain materials if there is no suggestion made to the fact that the witness departed from the truth. The defendant contends that there is evidence before you indicating that some other person than him that may have committed the crime or crimes, and the evidence raises a reasonable doubt with respect to the defendant's guilt. In this regard, I charge you that a defendant in a criminal case has the right to rely on evidence produced at trial that has a rational tendency to raise a reasonable doubt with respect to his own guilt. I have previously charged you regarding the state's burden of proof, which never shifts to the defendant. The defendant does not have to produce evidence that proves the guilt of another, but may rely on evidence that creates a reasonable doubt. In other words, there is no requirement that this evidence proves or raises a strong probability. You must decide whether the state has proven the defendant's guilt beyond a reasonable doubt. You must decide whether the person or persons may have committed the crimes. As you know, Paul Caneiro elected not to testify at trial. It is his constitutional right to remain silent. You must not consider for any purpose or in any manner in arriving at your verdict the fact that Paul Caneiro did not testify. That fact should never enter into your deliberations or discussions at any time or in any manner. Paul Caneiro is entitled to for the jury to consider all the evidence presented at trial. He is presumed innocent whether or not he chooses to testify. All right, ladies and gentlemen, we've been going at this for about 55 minutes. Can you stand up for me for a minute? I would just want you to stretch out yourself a minute or two. We're about to go into part 3.
The judge, halfway through his instructions, calls for a yoga break.
Take your time.
We would have taken 15 breaks in the closing if we'd used the same schedule. We're really hauling through it.
Okay. The third part deals with the criminal code, which will give you the elements of the charges for each one of the crimes in the indictment. I'm going to be providing you with a lot of information. Don't panic. Just listen to what I have to say. I promise you by the time that this is over, I will make sure that it is easy for you. Right now, I just want you to listen to what I'm telling you. Try to digest it as much as you can. But again, just wait until the end, and then we'll talk about it. Okay? Now I will instruct you on the third part of the instructions on the portions of the criminal code that you must apply to the facts you find in determining whether the state has proven it beyond a reasonable doubt that the defendant violated a specific criminal statute. The statute read together with the indictment identifies the elements which the state must prove beyond a reasonable doubt to establish the guilt of the defendant on each of the counts in the indictment. In addition, you will have the opportunity to consider other offenses besides beside those charged in the indictment. This is what we call a lesser offense, crime or offense of a lesser degree that is included within the charges brought in the indictment. I will give you instructions about how to consider this lesser offense shortly. There are multiple charges in the indictment. They are separate offenses by separate counts in the indictment. In your determination of whether the state has proven the defendant is guilty of the crimes charged in the indictment beyond a reasonable doubt, the defendant is entitled to have each count considered separately by the evidence which is relevant and material to that particular charge based on the law as I will give it to you. Now I'm going to talk to you about a lesser included offense. The law requires that the court instruct the jury with respect to a possible lesser included offense or offenses, even if they are not contained in the indictment. Here, there is a lesser included offense of arson relative to the aggravated arson charged against the defendant Paul Caneiro in count 8 of the indictment. Just because the court is instructing you concerning this offense does not mean that the court has an opinion one way or another about whether the defendant committed this or any other offenses. You should consider these offenses along with those for which the defendant is indicted. However, you are not to render a verdict on this offense or answer the question on the verdict sheet unless you find that the state has failed to meet its burden regarding the offense of aggravated arson in count 8 of the indictment. Now I'm going to talk to you about the substantive charges in this case. Counts 1 through 4 charges the defendant with the murder of 4 different victims. In count 1 of the indictment, the defendant is charged with the murder of Keith Caneiro. The state alleges that on November 20th, 2018, in the township of Colts Neck, county of Monmouth, the defendant committed the crime of murder by purposely or knowingly causing the death of Keith Caneiro, or by purposely or knowingly causing serious bodily injury that resulted in the death of Keith Caneiro. In count 2 of the indictment, the defendant is charged with the murder of Jennifer Caneiro. The state alleges that on November 20th, 2018, in the township of Colts Neck, county of Monmouth, the defendant committed the crime of murder by purposely or knowingly causing the death of Jennifer Caneiro, or by purposely or knowingly causing serious bodily injury that resulted in the death of Jennifer Caneiro. In count 3 of the indictment, the defendant is charged with the murder of Jesse Caneiro. The state alleges that on November 20th, 2018, in the township of Colts Neck, county of Monmouth, the defendant committed the crime of murder by purposely or knowingly causing the death of Jesse Caneiro, or by purposely or knowingly causing serious bodily injury that resulted in the death of Jesse Caneiro. In count 4, the defendant is charged with the murder of Sophia Caneiro. The state alleges that on November 20th, 2018, in the township of Colts Neck, county of Monmouth, the defendant committed the crime of murder by purposely or knowingly causing the death of Sophia Caneiro, or by purposely or knowingly causing serious bodily injury that resulted in the death of Sophia Caneiro. The statute upon which these 4 charges are based provides that a person is guilty of murder if he, 1, caused the death or serious bodily injury that then resulted in the victim's death. 2, the defendant did so purposely or knowingly. For you to find the defendant guilty of murder, the state is required to prove each of the following elements beyond a reasonable doubt. Number 1, that the defendant caused per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, per count 4, Sophia Caneiro's death, or serious bodily injury that then resulted in per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, per count 4, Sophia Caneiro's death. And 2, that the defendant did so purposely or knowingly. The first element that the state must prove beyond a reasonable doubt is that the defendant acted purposely or knowingly. A person acts purposely when it is the person's conscious object to cause death or serious bodily injury resulting in death. A person acts knowingly when the person is aware that it is practically certain that his conduct will cause death or serious bodily injury resulting in death. The nature of the purpose or knowledge with which the defendant acted towards per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, and per count 4, Sophia Caneiro, is a question of fact for you, the jury, to decide. Purpose and knowledge are conditions of the mind, which cannot be seen and can only be determined by inferences from conduct, words, or acts. It is not necessary for the state to produce a witness or witnesses who could testify that the defendant stated, for example, that his purpose was to cause death or serious bodily injury resulting in death, or that he knew that his conduct would cause death or serious bodily injury resulting in death. It is within your power to find that the proof of purpose or knowledge has been furnished beyond a reasonable doubt by inferences which may arise from the nature of the acts and the surrounding circumstances. Such things as the place where the acts occurred, in the beginning when we started 110 years ago, the location, the number and nature of the wounds inflicted, and all that was done or said by the defendant preceding, connected with, and immediately succeeding the events leading to the death of per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, and per count 4, Sophia Caneiro, are among circumstances to be considered. Although the state must prove that the defendant acted either purposely or knowingly, the state is not required to prove a motive. If the state has proved the essential elements of the offenses beyond a reasonable doubt, the defendant must be found guilty of the offense regardless of the defendant's motive or lack of motive. If the state, however, has proved a motive, you may consider that insofar as it gives meaning to other circumstances. On the other hand, you may consider the absence of motive in weighing whether the defendant is guilty of the crime charged. A homicide or a killing with a deadly weapon, such as a firearm and/or a knife, would permit you to draw an inference that the defendant's purpose was to take life or cause serious bodily injury resulting in death. A deadly weapon is any firearm or other weapon, device, instrument, material, or substance which in the manner it was used or is intended to be used is known to be capable of producing death or serious bodily injury. In your deliberations, you may consider the weapon used and the manner and circumstances of the killings. If you are satisfied beyond a reasonable doubt that the defendant shot and killed Keith Caneiro with a firearm, you may draw an inference from the weapon used, that is a firearm, and from the manner and circumstances of the killing as to the defendant's purpose or knowledge. If you are satisfied beyond a reasonable doubt that the defendant shot and/or stabbed and killed Jennifer Caneiro with a firearm and/or a knife, you may draw an inference from the weapon used that the firearm and/or the knife and the manner and circumstances of the killing as to the defendant's purpose or knowledge. If you're satisfied beyond a reasonable doubt that the defendant shot and/or stabbed and killed Jesse Caneiro with a firearm and/or a knife, you may draw an inference from the weapon used that is the firearm and/or knife and from the manner and circumstances of the killing as to the defendant's purpose or knowledge. If you are satisfied beyond a reasonable doubt that the defendant stabbed and killed Sofia Caneiro with a knife, you may draw an inference from the weapon used, that is the knife, and from the manner and the circumstances of the killing as to the defendant's purpose or knowledge. The second element that the state must prove beyond a reasonable doubt is the defendant caused, per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, per count 4, Sofia Caneiro's death or serious bodily injury resulting in death. As I previously advised you, to convict the defendant of murder, the state must prove beyond a reasonable doubt that the defendant either purposely or knowingly caused the victim's death or serious bodily injury that resulted in death. In that regard, serious bodily injury means bodily injury that creates a substantial risk of death. A substantial risk of death exists where it is highly probable that the injury will result in death. In order for you to find the defendant guilty of purposeful serious bodily injury murder, the state must prove beyond a reasonable doubt that it is the defendant's conscious object to cause serious bodily injury that then resulted in the victim's death, and that the defendant knew that the injury created a substantial risk of death, and that it is highly probable that the death would result. In order for you to find the defendant guilty of knowing serious bodily injury murder, the state must prove beyond a reasonable doubt that the defendant was aware that it was practically certain that his conduct would cause serious bodily injury that then resulted in the victim's death, that the defendant knew that the injury created a substantial risk of death, and that it was highly probable that death would result. Whether the killing is committed purposely or knowingly, causing death or serious bodily injury resulting in death, must be within the design or contemplation of the defendant. All jurors do not need to agree unanimously concerning which form of murder is present, so long as all believe that it was one form of murder or another. However, for a defendant to be guilty of murder, all jurors must agree that the defendant either purposely or knowingly caused the death or serious bodily injury resulting in the death of, per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, and per count 4, Sofia Caneiro. If, after consideration of all the evidence, you are convinced beyond a reasonable doubt that the defendant either purposely or knowingly caused, per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, per count 4, Sofia Caneiro's death or serious bodily injury resulting in death, then your verdict must be guilty as to that specific count of murder. If, however, after all of the consideration of the evidence, you find that the state has failed to prove any element of the offenses beyond a reasonable doubt, then your verdict must be not guilty as to that specific count of murder. As to purposeful or knowing murder counts, the state alleges that the defendant acted by his own conduct in causing the death of, per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, per count 4, Sofia Caneiro. If you unanimously find that the defendant either purposely or knowingly caused the death of or serious bodily injury resulting in the death of, per count 1, Keith Caneiro, per count 2, Jennifer Caneiro, per count 3, Jesse Caneiro, per count 4, Sofia Caneiro, you must also decide whether the state has proven beyond a reasonable doubt that the defendant committed the homicidal act by his own conduct. A finding of own conduct does not require a specific finding that the defendant's actions standing alone caused the victim's death. The relevant inquiry is whether the defendant actively and directly participated in the homicidal act or acts. The critical elements are whether the defendant acted and the immediacy of his conduct to the victim's demise. In other words, the defendant must be the direct and immediate cause of death to satisfy the own conduct element. Now, I want to give you the verdict sheet for a minute.
The verdict sheet, not the burn sheet. We are close. We're at the verdict sheet. They'll go through the verdict, then they'll tell them how to deliberate, and we're done.
What I'm asking you to do is not to flip through it. Just we're going to start right from the top for a minute.
Don't read ahead,
If
jurors.
you find the defendant committed the crime of purposeful knowing murder, and you unanimously agree that the state has proven beyond a reasonable doubt that he acted by his own conduct, you must answer yes to the own conduct question on the verdict sheet. You'll then be asked questions as it relates to the count in the indictment. So if you're looking at that right now, you see as to count 1, we're talking about Keith Caneiro. You'll answer the question, guilty or not guilty, as it relates to the crime of murder. The sub-questions underneath, the first question you're going to answer is whether it's done by his own conduct. You're going to answer that yes or no. Remember, you only get to own conduct if you found him guilty of the murder of Keith Caneiro. The next question would be yes or no, whether it was by his own conduct. If the answer to that is yes, then we're going to go to the other questions that you see there, which would then be 1B. And this is where we are. Okay, so 1A is that it's by his own conduct, and now let's go to 1B. The question is, did the defendant, Paul Caneiro, commit the murder in expectation of the receipt of anything of pecuniary value? If you unanimously agree that the state has proven beyond a reasonable doubt that the defendant did commit the murder in expectation of the receipt of anything of pecuniary value, then you must answer yes on the expectation of the receipt of a pecuniary value question. If the defendant, if you find the defendant committed the crime of purposeful or knowing murder, but you find that the state did not prove beyond a reasonable doubt that he committed the murder in expectation of the receipt of anything of value, then you must answer no to the expectation of the receipt of pecuniary value question. You'll still go, no matter what you answer for 1B, if you're now into these subsections, you're going to answer each one of them. You're going to answer B, C, and D, no matter what, if you've answered that he's guilty to count 1 and that he did it by his own conduct. Does that make sense, everybody?
Yes.
Okay, so let's go to C, no matter what you say on B. If you find that the defendant committed the crime of purposeful or knowing murder and that he committed the crime by his own conduct, and you unanimously agree that the state has proven beyond a reasonable doubt that he committed the murder for the purpose of escaping detection, apprehension, trial, punishment, or confinement for another offense committed by the defendant, then you must answer yes to the committed for the purpose of escaping question on the verdict sheet. If you find the defendant committed the crime of purposeful or knowing murder, but you find the state did not prove beyond a reasonable doubt that he committed the murder for the purpose of escaping detection, apprehension, trial, punishment, or confinement for another offense committed by the defendant, then you must answer no on that part of the verdict sheet. As to count 1D, if you find unanimously that the defendant acted by his own conduct, you will need to determine whether the defendant committed the murder of Keith Caneiro while the defendant was engaged in the commission of, or an attempt to commit, or flight after committing or attempting to commit murder. If you find that the defendant committed the crime of purposeful knowing murder while the defendant was engaged in the commission of, or attempt to commit, or flight after committing or attempting to commit murder, and you unanimously agree that the state has proven beyond a reasonable doubt that he committed the murder while engaged in the commission of, or an attempt to commit, or flight after committing or attempting to commit murder, then you must answer yes to while in the course of a murder question on the verdict sheet. If you find that the defendant committed the crime of knowing and purposeful murder, but you find the state did not prove beyond a reasonable doubt that he committed the murder while engaged in the commission of or an attempt to commit or flight after committing or attempting to commit murder, then you must answer no on the while in the course of murder question on the verdict sheet. So that analysis that we just talked about, you're going to do that same exact analysis for Jennifer. If you find her defendant guilty of the murder of Jennifer Caneiro, and it is by his own conduct, you're going to answer those subsection questions. When we get to Jesse and the Sophia, Jesse is count 3, you're going to answer another question. Let's go to that one for a second. So if we're looking at that, we're now, all of us should be on page, I think it's on page 5, but let me just confirm. Yeah, see, 4 deals with JC, which is Jesse Caneiro. So if you go to page 5, which is where E is located, that's the other question that we're going to ask for this one. As to Jesse and Sophia Caneiro, you will have additional questions. If you find unanimously that the defendant acted by his own conduct, you will also need to determine whether per count 3 Jesse Caneiro, per count 4 Sophia Caneiro were less than 14 years old. If you find that per count 3 Jesse Caneiro, per count 4 Sophia Caneiro were less than 14 years old, and you unanimously agree that the state has proven beyond a reasonable doubt that the defendant committed the murder per count 3 Jesse, per count 4 Sophia, while they were less than 14 years old, then you would answer yes to the victim was less than 14 years old question on the verdict sheet. If you find the defendant committed the crime of purposeful or knowing murder, but you find that the state did not prove beyond a reasonable doubt that the defendant committed the murder while each one of them, Jesse and Sophia, were under the age of 14, then you would answer no. So if you find that the state didn't prove that they were under the age of 14, then you would be answering no to that question, and that's E for each one of count 3 and for count 4. Does everyone see that on the verdict sheet? Yes. Okay, great. Now we're going to take all your verdict sheets back for a minute. So you just pass them down, that'd be great. Okay, the next charge is, the next 2 charges are for felony murder. Defendant is charged in count 5 of the indictment with the felony murder of Jesse Caneiro. The indictment reads in pertinent part as follows. Paul Caneiro, on or about November 20th, 2018, in or about the township of Colts Neck, County of Monmouth, did commit the crime of felony murder by causing the death of Jesse Caneiro while engaged in the commission of or an attempt to commit or in the flight after committing or attempting to commit the crime of arson. The defendant is charged in count 6 of the indictment with the felony murder of Sophia Caneiro. The indictment reads in pertinent part as follows. Paul Caneiro, on or about November 20th, 2018, in or about the township of Colts Neck, County of Monmouth, did commit the crime of felony murder by causing the death of Sophia Caneiro while engaged in the commission of or an attempt to commit and or flight after committing or attempting to commit the crime of arson. The state contends that on November 20th, 2018, while the defendant was engaged in the commission of or attempt to commit or flight after committing or attempting to commit the crime of arson, he stabbed and killed Jesse Caneiro and or Sophia Caneiro. The section of the statute applicable to this case reads in pertinent part as follows. Criminal homicide constitutes murder when it is committed when the actor is engaged in the commission of or attempt to commit or flight after committing or attempting to commit arson, and in the course of such crime or the immediately flight therefrom causes the death of a person other than one of the participants. Generally, it does not matter that the act which caused death was committed recklessly or unintentionally or accidentally. The perpetrator is as guilty of felony murder as he would be if he had purposely or knowingly committed the act which caused death. For you to find the defendant guilty of felony murder, the state is required to prove beyond a reasonable doubt from all the evidence in the case all the essential elements of the crimes charged. Accordingly, before you can find the defendant guilty of the felony murder of Jesse Caneiro in count 5 or Sophia Caneiro in count 6, the state must prove beyond a reasonable doubt that 1, on or about November 20th, 2018, the defendant was engaged in the commission of or attempt to commit or flight after committing or attempting to commit the crime of arson as noted as the lesser included offense of count 7, that the death of per count 5 Jesse Caneiro, per count 6 Sophia Caneiro was caused by the defendant, and number 3, that the death of per count 5 Jesse Caneiro, per count 6 Sophia Caneiro was caused at some time within the course of the commission of that crime, including its aftermath of flight and concealment efforts. The first element requires the state to prove beyond a reasonable doubt that the defendant was engaged in the commission of or attempt to commit or flight after committing or attempting to commit the crime of arson. In order for you to find the defendant guilty of arson, the state is required to prove each of the following elements beyond a reasonable doubt. That the defendant purposely started a fire at 15 Willowbrook Road in Colts Neck, New Jersey. 2, that the act of starting the fire recklessly placed per count 5 Jesse Caneiro, per count 6 Sophia Caneiro, in danger of death or bodily injury. You cannot find the defendant guilty of felony murder unless you first find him guilty beyond a reasonable doubt of having committed the crime of arson. And again, arson, as we're talking about here, is not what's charged in the indictment that I'm going to talk to you about in a minute, which is aggravated arson. This is the lesser offense of arson of what we're talking about. So for you to find him guilty of this charge, he has to be guilty of arson first. Everybody get that? All right. The second and third elements require the state to establish that per count 5 Jesse Caneiro, per count 6 Sophia Caneiro's death was caused by the defendant and was caused during the commission of or attempt to commit or flight after committing or attempting to commit crime of arson. To meet its burden of proof as to the second and third elements pursuant to count 5 and 6, the state must prove beyond a reasonable doubt the following. 1, that but for the defendant's conduct in the commission of or attempt to commit or flight after committing or attempting to commit arson, Jesse Caneiro and or Sophia Caneiro would not have died. In other words, that Jesse Caneiro and or Sophia Caneiro's death would not have occurred without the commission of the arson. Number 2, Jesse Caneiro and or Sophia Caneiro's death was a probable consequence of the commission of or attempt to commit or flight after committing or attempting to commit arson. For the death to be the probable consequence of the arson, the death must not have been too remote or too accidental in its occurrence or too independent on another's volitional acts to have a just bearing on the defendant's liability or the gravity of his offense. In other words, you must decide that if the state has proven beyond a reasonable doubt, then under all of the circumstances, the death did not occur in such an unexpected or unusual manner that it would be unjust to find the defendant responsible for the death. In conclusion, if you find the state has proven beyond a reasonable doubt that 1, the defendant was engaged in the commission of or attempt to commit or flight after committing or attempting to commit the crime of arson, 2, that Jesse and or Sophia's death was caused by the defendant, and 3, that the death of the person was caused at some time within the course of the commission of the crime, including its aftermath or flight and concealment efforts, then you must find the defendant guilty of felony murder. On the other hand, if you find that the state has failed to prove beyond a reasonable doubt any one or more of those elements beyond a reasonable doubt, then you must find the defendant not guilty of felony murder. If you find that the state has failed to prove beyond a reasonable doubt that the defendant caused the death of Jesse Caneiro and/or Sofia Caneiro, then the defendant should be found not guilty of all charged homicide offenses, including these two victims. If, however, you find beyond a reasonable doubt that the defendant did cause the death of Jesse Caneiro and/or Sofia Caneiro, but that the state has failed to prove beyond a reasonable doubt that the defendant was at the time engaged in the course of the commission of or attempt to commit or flight after committing or attempting to commit arson, then you still can consider the separate crime of murder. All right, counts 7 and 8. They both deal with aggravated arson. Count 7 of the indictment charged the defendant with aggravated arson in violation of 2C 17-1A. The indictment reads in pertinent part as follows. Paul Caneiro, on or about November 20th, 2018, in or about the township of Colts Neck, county of Monmouth, did commit the crime of aggravated arson by starting a fire, thereby purposely or knowingly placing Jesse Caneiro and/or Sofia Caneiro in danger of death or bodily injury, and/or with the purpose of destroying a building and/or structure of another, to wit, 15 Willowbrook Road, Colts Neck, New Jersey, belonging to Keith and/or Jennifer Caneiro. As to count 8, again, an aggravated arson charge. The indictment reads, Paul Caneiro, on or about November 20th, 2018, in or about the township of Ocean, county of Monmouth, did commit the crime of aggravated arson by starting a fire, thereby purposely or knowingly placing Susan Caneiro and/or Marissa Caneiro and/or Caitlin Caneiro in danger of death or bodily injury, to wit 27 Tilton Drive, Ocean, New Jersey, belonging to Paul Caneiro and/or Susan Caneiro. The section of the statute applicable to this case reads in pertinent part as follows. A person is guilty of aggravated arson if he starts a fire or causes an explosion, whether on his own property or another's. 1, thereby purposely or knowingly placing another person in danger of death or bodily injury, and/or 2, with the purpose of destroying a building or structure of another. For the defendant to be found guilty of aggravated arson, the state must prove the following elements beyond a reasonable doubt. 1, that the defendant purposely started a fire per count 7 at 15 Willowbrook Road in Colts Neck, per count 8 on his own property at 27 Tilton Drive in the township of Ocean. 2, that the act of starting the fire, A, purposely or knowingly placed, per count 7, Jesse or Sofia Caneiro, per count 8, Susan or Marissa or Caitlin Caneiro, in danger of death or or bodily injury, not serious bodily injury. And/or 3, was done with the purpose of destroying a building or structure of another, to wit, per count 7, 15 Willowbrook Road in Colts Neck, per count 8, on his own property of 27 Tilton Drive in the township of Ocean. So you're looking at 2 different ways the state can prove aggravated arson. It's either by way of causing danger of death or bodily injury to the individuals within the home, or for the purpose of destroying a building or structure of another, or in count 8 dealing with Paul Caneiro's own structure or house, okay? The first element that the state must prove beyond a reasonable doubt is 1, that the defendant purposely started a fire at or near premises known as per count 7, 15 Willowbrook Road in Colts Neck, and count 8, his own property at 27 Tilton Drive in Ocean. A person acts purposely with respect to the nature of his conduct or a result thereof if it is his conscious object to engage in conduct of that nature or cause such a result. A person acts purposely with respect to attendant circumstances if he is aware of the existence of such circumstances or believes or hopes they exist. With purpose, design, with design, or equivalent terms have the same meaning. Purpose is a condition of the mind that cannot be seen and can only be determined by inferences drawn from the defendant's conduct, words, or acts. It is not necessary for the state to prove the existence of such a mental state by direct evidence, such as a statement by the defendant that he had a particular purpose. It is within the power of the jury to find that the proof of purpose has been furnished beyond a reasonable doubt by inferences which you may draw from the nature of the acts and the circumstances surrounding the conduct of the defendant as they have been presented in the evidence you have heard and seen in this case. It is not necessary that any significant damage be done. It's only necessary that a fire be started for one or more of the purposes to be described. The lack of success of the perpetrator is immaterial. 2, the second element the state must prove beyond a reasonable doubt is that at the time the defendant started the fires, he purposely or knowingly placed, per count 7, Jesse and Sophia, per count 8, Susan, Marissa, or Caitlin in danger of death or bodily injury. Or his purpose was to destroy 15 Willowbrook in count 7 or 27 Tilton in count 8. Bodily injury means physical pain, illness, or other impairment of physical condition. I have already defined the term purposely for you. A person acts knowingly with respect to the nature of his conduct or the attendant circumstances if he is aware that his conduct is of such a nature or that of such circumstances. Let me start over. A person acts knowingly with respect to the nature of his conduct or the attendant circumstances if he is aware that his conduct is of that nature or that such circumstances exist, or he is aware of a high probability of their existence. A person acts knowingly with respect to a result of his conduct if he is aware that it is practically certain that his conduct will cause such a result. Knowledge is a condition of the mind that cannot be seen and can only be determined by inferences drawn by the defendant's conduct, words, or acts. It is not necessary for the state to prove the existence of such a mental state by direct evidence, such as a statement by the defendant that he had a particular knowledge. It is within the power of the jury to find the proof of knowledge that has been furnished beyond a reasonable doubt by inferences which you may draw from the nature of the acts and the circumstances surrounding the conduct of the defendant as they have been presented in the evidence you have heard and seen in this case. Destroy means to demolish and or render useless and or render completely ineffective for its intended use. If you find that the state has proven all the elements of aggravated arson beyond a reasonable doubt, then you must find him guilty of aggravated arson. On the other hand, if you find that the state has failed to prove all the elements of the aggravated arson beyond a reasonable doubt, then you must find the defendant not guilty.
I'm impressed the judge still has dynamics to his reading style.
Talk to you about the lesser included offense of aggravated arson, which is arson. A lesser included offense to aggravated arson is in the indictment is arson. Can I see the attorneys for a second?
Judge just found a mistake in the paperwork, which means we get a little bit of a break. I did not time the judge, but he has been talking, I think, for over an hour, and is someone timing the judge? I don't know. It's not going to be as long as the others. But I also might have to take back my promise that we're going to be deliberating today. We might not start till tomorrow. Judge started at 1:53. It's now 3, so that's 2 to 3. So over an hour.
Remember in the beginning when we started 110 years ago?
Yeah, I thought that was the judge. Who played that sound? Josh. Yes, we did. I acted very quickly and added that sound to the sound effect.
Why don't you guys take a stretch for a second? You're more than halfway home.
Come on, we should be at least 3/4, Judge.
Remember in the beginning when we started 110 years ago?
The new command was this one right here, exclamation point 110. It gives this command that we heard from, it was actually in the judge's instructions. That's how quick I made it. I made it while he was still giving instructions. It's a new record for me.
Remember in the beginning when we started 110 years ago? Anyone think I could touch the ceiling if I jumped?
Probably.
Let's see.
Remember in the beginning when we started 110 years ago? Definitely here for your entertainment. I just want to.
At least the camera.
I'm going to say with absolute certainty I can't do it.
Camera? Yeah.
I think I can get the camera. And then, no my luck, I'll knock it off.
Judge is stretching and jumping, I guess. Apparently he's got mad hops.
Right? 6 inches maybe. At least.
He says he's got at least a 6-inch. Little ASMR from the judge.
Ladies and gentlemen, before when I was talking about the lesser included offense and you heard me stop for a second, one thing we're going to fix in the charge is that it's actually counts 7 and 8. So you will consider aggravated arson. Obviously, the indicted charge is for 7 and 8. If you found him not guilty of aggravated arson, then you would consider arson for both counts 7 and 8, not just one of them. So I'm gonna fix that for you, but I also want to fix it for you verbally. Okay. All right. As I previously stated, the law requires that the court instruct the jury with respect to a possible lesser included offense, even if they are not contained in the indictment. Just because the court is instructing you concerning these offenses does not mean the court has an opinion one way or another. You should consider these offenses along with those for which the defendant is indicted. However, you are not to render a verdict on these offenses or answer the questions on the verdict sheet unless you find that the state has failed to meet one of the elements of aggravated arson in count 7 and or 8 beyond a reasonable doubt. Here's the elements of arson. A person is guilty of arson if he purposely causes a fire or it's getting good now. A person is guilty of arson if he purposely starts a fire or causes an explosion, whether on his own property or another's. 1, thereby recklessly placing another person in danger of death or bodily injury. In order for the defendant to be found guilty of arson, the state must prove beyond a reasonable doubt the following elements. Number 1, that the defendant purposely started the fire on either 15 Willowbrook
The judge just froze, hand in the air.
The fire, recklessly placed At 15 Willowbrook, it would be Keith Caneiro and Jennifer Caneiro. At 27 Tilton, it would be Susan Caneiro, Marissa Caneiro, or Caitlin Caneiro in danger of death or bodily injury. The first element that the state must prove beyond a reasonable doubt is that the defendant purposely started a fire. It is not necessary that any significant damage be done. It's only necessary that a fire be started purposely. The lack of success of the perpetrator is immaterial. I've already defined purposely for you. For the state to prove this element of the offense, you must be satisfied beyond a reasonable doubt that it was the defendant's purpose or conscious object to start a fire. The second element the state must prove beyond a reasonable doubt is that the defendant, by purposely starting the fire, recklessly placed at 15 Willowbrook, it would be Keith Caneiro, it is, all right, I got to start over. I
found another mistake. No, Judge. Page 1.
When we're talking about the arsons, as you recall, we were talking about, give me a second.
Did he just leave? Did he just get up and leave? Somebody just ripped one. Little toot. Family members are bailing as well. I was going to tell you a few minutes ago, Thomas is at Bucky's. If you need him to pick something up for you, I guess you can tell me and I'll
remember in the beginning when we started.
Alex stolen as well.
Why did Alex step on 110 years ago?
Remember in the beginning when we started 110 years ago?
I think he said he was getting me some ghost pepper jerky. So
All right.
we'll see.
I'm trying to have court.
Bucky's is the world's largest gas station. All right, judge is back.
Okay. A person is guilty of arson if he purposely starts a fire or causes an explosion, whether on his own property or another's. Another. 1, thereby recklessly placing another person in danger of death or bodily injury. In order to find the defendant to be guilty of arson, the state must prove the following elements beyond a reasonable doubt. That the defendant purposely started a fire at 15 Willowbrook Road, Colts Neck, New Jersey, and or 27 Tilton Drive in the Township of Ocean, New Jersey, and that the act of starting the fire recklessly placed at 15 Willowbrook Road, Jennifer Caneiro and or Keith Caneiro, and at 27 Tilton, Susan Caneiro or Marissa Caneiro or Caitlin Caneiro in danger of death or bodily injury. The first element that the state must prove beyond a reasonable doubt is that the defendant purposely started a fire. It is not necessary that any significant damage be done. It is only necessary that a fire be started on purpose. The lack of success of the perpetrator is immaterial. I have already defined purposely for you. For the state to prove this element of the offense, you must be satisfied beyond a reasonable doubt that it was the defendant's purpose or conscious object to start the fire. The second element the state must prove beyond a reasonable doubt is that the defendant, by purposely starting the fire, recklessly placed Keith Caneiro and or Jennifer Caneiro at 15 Willowbrook Road, or Susan Caneiro or Marissa Caneiro or Caitlin Caneiro at 27 Tilton in danger of death or bodily injury. Bodily injury means physical pain, illness, or any other impairment of physical condition. I've already defined the term purposely for you. A person acts recklessly when he consciously disregards a substantial and unjustifiable risk. The risk must be of such a nature and degree that, considering the nature and purpose of the actor's conduct and the circumstances known to him, its disregard involves a gross deviation from the standard of conduct that a reasonable person would observe in the actor's situation. If the state has failed to prove any of the elements as I've described to you beyond a reasonable doubt, you must find the defendant not guilty of arson. If you find the state has proven every element of the crimes charged beyond a reasonable doubt, then you would find him guilty of arson. So what's the difference between aggravated arson and arson? The act of purposely starting the fire is the same for aggravated arson and arson. The difference becomes in the second portion, whether he acted purposely or knowingly, putting these individuals, the victims, in the position of either in danger of either death or bodily injury. Purposely or knowingly for aggravated arson, recklessly for arson. So it's just the mental state that changes between aggravated arson and arson. Does that make sense? Okay. My confusion was just dealing with, I want to make sure that I was clear with the victims' names. Okay, we're going to count 9. Count 9 of the indictment charges the defendant Paul Caneiro with the crime of possession of a firearm with the purpose to use it unlawfully against the person of another. The indictment reads in pertinent part as follows. Paul Caneiro, on or about November 20th, 2018, in or about the township of Colts Neck, county of Monmouth, did commit the crime of possession of a firearm with the purpose to use it unlawfully against the person of another by possessing a handgun with the purpose to use it against Keith Caneiro and or Jennifer Caneiro and or Jesse Caneiro and or Sophia Caneiro. The statute on which this count of the indictment is based reads in pertinent part. Any person who has in his possession any firearm with a purpose to use it unlawfully against the person or property of another is guilty of a crime. For you to find the defendant guilty on this charge, the state has the burden of proving beyond a reasonable doubt each of the following 4 elements of this crime. 1. Exhibit S-193 is a firearm. 2. Defendant possessed the firearm. 3. Defendant possessed the firearm with the purpose to use it against another person or a person of another. 4. Defendant's purpose was to use the firearm unlawfully. The first element that the state must prove beyond a reasonable doubt is that S-193 is a firearm. A firearm means any handgun, rifle, shotgun, machine gun, automatic or semi-automatic rifle, or any gun, device, or instrument in the nature of a weapon from which may be fired or ejected any solid projectile ball, slug, pellet, missile, or bullet, or any gas, vapor, or other noxious thing by means of a cartridge or shell, or by the action of an explosive, or the igniting of flammable or explosive substances.
That's a pretty broad definition.
It shall also include, without limitation, any firearm which is in the nature of an air gun, spring gun, or pistol, or other weapon of such a nature in which the propelling force is a spring, elastic band, carbon dioxide, compressed or other gas or vapor, air or compressed air, or is ignited by compressed air and ejecting a bullet or missile smaller than 3/8 of an inch in diameter with sufficient force to injure a person.
Holy smokes. New Jersey, your definition of gun is so broad that
the second element that the state must prove beyond a reasonable doubt
a Nerf
is the
gun
defendant
qualifies.
possessed the firearm. To possess an item under the law, one must have a knowing, intentional control of that item accompanied by a knowledge of its character. So a person who possesses an item such as a handgun must know or be aware that he possesses it, and he must know that that he possesses or controls that it is a handgun. Possession cannot merely be a passing control, fleeting or uncertain in its nature. In other words, to possess an item, one must knowingly procure or receive an item or be aware of his control thereof for a sufficient period of time to have been able to relinquish his control if he chose to do so. The state must prove beyond a reasonable doubt that a possessor acted knowingly in possessing the item. A person acts knowingly with respect to the nature of his conduct or the attendant circumstances if he is aware that the conduct is of that nature, or that such circumstances exist, or he is aware of the high probability of their existence. A person acts knowingly as to the result of his conduct if he is aware that it is practically certain that the conduct will cause such a result. Knowing with knowledge or equivalent terms have the same meaning. As I told you in the past, knowledge is a condition of the mind. It can't be seen. It can be determined only from inferences, from conduct, words, or acts. Therefore, it's not necessary for the state to produce a witness to testify that a particular defendant stated, for example, that he acted with knowledge when he had control over a particular thing. It is within your power to find the proof of knowledge has been furnished beyond a reasonable doubt by inference, which may arise from the nature of the acts and the surrounding circumstances. A person may possess an item even though it was not physically on his person at the time of the arrest, if he had, in fact, at some point prior to his arrest, had control over it. Possession means a conscious, knowing possession, either actual or constructive. A person is in actual possession of an item when he first knows what it is. That is, he has knowledge of its character, and second, knowingly has it on his person at a given time. The third element that the state must prove beyond a reasonable doubt is that the defendant's purpose in possessing the firearm was to use it against the person of another. Purpose is a condition of the mind which cannot be seen and can only be determined by inferences from conduct, words, or acts. In determining the defendant's purpose in possessing the firearm, you may consider that a person acts purposely with respect to the nature of his conduct or a result of his conduct if it is in the person's conscious object to engage in conduct of that nature or to cause such a result. That is, a person acts purposely if he means to act in a certain way or to cause a certain result. A person acts purposely with respect to attendant circumstances if the person is aware of the existence of such circumstances or believes or hopes that they exist. The defendant's purpose or conscious objective to use the firearm against another person or the property of another may be found to exist at any time he has the possession of the object and need not have been the defendant's original intent in possessing the object. The fourth element that the state must prove beyond a reasonable doubt is that the defendant had a purpose to use the firearm in a manner that was prohibited by law. I've already defined purpose for you. This element requires that you find the state has proven beyond a reasonable doubt that the defendant possessed a firearm with a conscious objective, design or specific intent to use it against the person or property of another in an unlawful manner as charged in the indictment and not for some other purpose. In this case, the state contends that the defendant's unlawful purpose in possessing the firearm was to use it unlawfully against the person of Keith Caneiro or Jennifer Caneiro or Jesse Caneiro or Sophia Caneiro. So that's the only thing you're looking at for his unlawful purpose, what I've just described to you. You must not rely upon your own notions of the unlawfulness of some other undescribed purpose of the defendant. Rather, you must consider whether the state has proven the specific unlawful purpose charged. The unlawful purpose alleged by the state may be inferred from all that was said or done and from all the circumstances of this case. However, the state need not prove the defendant accomplished his unlawful purpose of using the firearm. If you find the state has failed to prove any of the elements of the crime beyond a reasonable doubt, your verdict must be not guilty. On the other hand, if you are satisfied that the state has proven each and every element of the crime charged beyond a reasonable doubt, your verdict must be guilty. The 11th count of the indictment charges the defendant with the crime of possession of a weapon for unlawful purpose to use it unlawfully against the person of another. The indictment reads in pertinent part as follows. Paul Caneiro, on November 20th, 2018, in or about the township of Colts Neck, county of Monmouth, did commit the crime of possession of a weapon for unlawful purpose by possessing a knife with the purpose to use it unlawfully against the person of Jennifer Caneiro and or Jesse Caneiro and or Sophia Caneiro. The statute on which this count of the indictment is based reads in pertinent part. A person who has in his possession any weapon with the purpose to use it unlawfully against the person or property of another is guilty of a crime. In order for you to find the defendant guilty of this charge, the state has the burden of proving beyond a reasonable doubt each of the following four elements. Number one, Exhibit S313 is a weapon. 2, defendant possessed a weapon. 3, defendant possessed a weapon with the purpose to use it against the person or property of another. 4, defendant's purpose was to use the weapon unlawfully. The first element the state must prove beyond a reasonable doubt is that S313 is a weapon. A weapon is anything readily capable of lethal use or of inflicting serious bodily injury. Serious bodily injury means bodily injury which creates a substantial risk of death or which causes serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. It is possible that a knife is not normally considered a weapon. If, however, the state established beyond a reasonable doubt that the object is capable of being used to inflict serious bodily injury or death, it may be considered a weapon. The second element that the state must prove beyond a reasonable doubt is that the defendant knowingly possessed the knife. I've already defined possession for you. I've already defined knowingly for you. And I've already told you that knowledge is a condition of the mind and it only can be determined based on inferences, conduct, words, or acts. A person may possess an item even though it was not physically on his person at the time of the arrest, if he had in fact at some time prior to his arrest had control over it. Possession means a conscious knowing possession, either actual or constructive. A person is in actual possession of an item when he first knows what it is, that is, he has knowledge of its character, and second, knowingly has it on his person at a given time. The third element that the state must prove beyond a reasonable doubt is that the defendant's purpose in possessing the object was to use it as a weapon against Jennifer Caneiro or Jesse Caneiro or Sophia Caneiro. As I told you in the past, purpose is a condition of mind that cannot be determined, that can't be seen. It can only be determined by inference from words, conduct, or acts. In determining the defendant's purpose in possessing the weapon, you may consider that a person act purposely with respect to the nature of the conduct or a result of his conduct if it is the person's conscious object to engage in conduct of that nature or to cause such a result. That is, a person acts purposely if he means to act in a certain way or to cause a certain result. A person acts purposely with respect to attendant circumstances if the person is aware of the existence of such circumstances or believes or hopes that they exist. Defendant's purpose or conscious object to use the weapon against the person or property of another may be found to exist at any time he is in possession of the object and need not have been the defendant's original purpose in possessing the object. The fourth element the state must prove beyond a reasonable doubt is that the defendant had a purpose to use a weapon in a manner that is prohibited by law. I've defined purpose for you already. This element requires that you find that the state has proven beyond a reasonable doubt that the defendant possessed a weapon with a conscious objective, design, or specific intent to use it against the person or property of another in an unlawful manner as charged in the indictment and not for some other purpose. An object may be possessed for an innocent or for a lawful purpose. However, an innocent or lawful purpose or possession of a weapon may change and become unlawful and a violation of this statute. The state need not prove the defendant's original purpose in possessing the weapon. The state need only prove beyond a reasonable doubt that the defendant's purpose at a specified time he possessed it was to use it unlawfully against the person or property of another. In this case, the state contends the defendant's unlawful purpose in possessing the knife was to commit serious bodily harm, resulting in the death of Jennifer Caneiro and or Jesse Caneiro and or Sophia Caneiro. You must not rely upon your own notions of the unlawfulness of some other undescribed purpose of defendant Rather, you must consider whether the state has proven the specific unlawful purpose charged. The unlawful purpose alleged by the state may be inferred from all that was said or done and from all the surrounding circumstances of this case. However, the state need not prove the defendant accomplished his unlawful purpose of using the weapon. If you are satisfied beyond a reasonable doubt that the state has proven each of the elements that I've defined to you beyond a reasonable doubt, then you should find him guilty. However, if you find that the state has failed to prove any of those elements beyond a reasonable doubt, then you would find him not guilty. Count 12 of the indictment charges the defendant with unlawful possession of a weapon. The indictment reads, Paul Caneiro, on or about November 20th, 2018, in or about the township of Colts Neck, county of Monmouth, did commit the crime of unlawful possession of a weapon by knowingly possess a knife under circumstances not manifestly appropriate for such lawful uses as it may have. That section of our statute provides in pertinent part, any person who knowingly has in his possession any other weapon under circumstances not manifestly appropriate for such lawful uses as it may have is guilty of a crime. To convict the defendant of this crime, the state must prove the following elements beyond a reasonable doubt. 1. S-313 is a weapon. Count 2, the defendant possessed a weapon knowingly. Count 3, defendant possessed a weapon under circumstances not manifestly appropriate for a lawful use. The first element that the state must prove beyond a reasonable doubt is that S-313 is a weapon. A weapon is anything readily capable of lethal use or of inflicting serious bodily injury. The second element the state must prove beyond a reasonable doubt is that the weapon was knowingly possessed by the defendant at a time and place alleged. Here the state alleges that the defendant possessed the weapon on or about November 20th, 2018 in Colts Neck, New Jersey. I've already defined knowingly for you. Knowledge is a condition of mind. It can't be seen. I've already explained how to analyze this mental state. Thus, the person must know or be aware that he possessed the item, here a knife, and then he must know what it is that he possesses or controls. In other words, that it is a knife. This possession cannot merely be a passing control that is fleeting or uncertain in its nature. In other words, to possess within the meaning of the law, the defendant must knowingly procure or receive the item possessed or be aware of his control thereof for a sufficient period of time to have been able to relinquish his control if he chooses to do so. When we speak of possession, we mean a conscious knowing possession. The law recognizes two kinds of possession, actual and constructive. A person is in actual possession of a particular article or thing when he knows what it is. That is, he has knowledge of its character and knowingly has it on his person at a given time. A person who, with knowledge of its character, knowingly has physical control over a thing at a given time is in actual possession of it. The law recognizes that possession may be sole or joint. If one person alone has actual or constructive possession of a thing, possession is sole. The third element that the state must prove beyond a reasonable doubt is that the defendant possessed S-313 and or another knife under circumstances not manifestly appropriate for such lawful uses as it may have. It is not necessary for the state to prove that the defendant formed an intent to use S-313 or any other knife as a weapon. It is, however, necessary for the state to prove that it was possessed under such circumstances that a reasonable person would recognize that it was likely to be used as a weapon. In other words, under circumstances where it posed a likely threat of harm to others. You may consider factors such as the surrounding circumstances, size, shape, and condition of the object, the nature of its concealment, the time, place, and actions of the defendant when it was found in his possession to determine whether the object was manifestly appropriate for its lawful use. If the state has proven each element beyond a reasonable doubt, each of the elements of this particular charge beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if the state has failed to prove any one of those three elements beyond a reasonable doubt, then you must find him not guilty. Count 13, theft. Count 13 of the indictment charges defendant with theft by unlawful taking or disposition of movable property. The indictment reads as follows. Paul Caneiro, bless you. Paul Caneiro, on or about diverse dates between January 1st, 2017 through November 19th through 2018, in or about various municipalities in the county of Monmouth, including but not limited to the Township of Ocean and or the Township of Colts Neck, county of Monmouth, did commit the crime of theft by unlawfully taking or exercising unlawful control over movable property of another, to wit, money valued at $75,000 or more belonging to Keith Caneiro or Jennifer Caneiro, Jesse Caneiro, and or Sophia Caneiro, with the purpose to deprive the owner thereof. The statute upon which the indictment is based provides, in pertinent part, that a person is guilty of theft if he unlawfully takes or exercises unlawful control over movable property of another with purpose to deprive him thereof. The state must prove each of the following elements beyond a reasonable doubt. 1, that the defendant knowingly took or unlawfully exercised control over movable property. 2, that the movable property was property of another. 3, that the defendant's purpose was to deprive the other person of the movable property. The first element which the state must prove beyond a reasonable doubt is that the defendant knowingly took or exercised unlawful control over movable property. Property means anything of value, including tangible and intangible personal property. Movable property means property with a location of which can be changed, including things growing on, affixed to, or found in land or documents, although the rights represented thereby have no physical location. For comparison purposes, immovable property is all other property. Defendant must knowingly take or exercise unlawful control over movable property. I've already defined knowingly for you. Knowledge is a condition of the mind. It can't be seen. I've already explained how to analyze that mental state. In this case, the state alleges that the movable property taken or over which control was unlawfully exercised is the following: money valued at $75,000 or more. It should be noted that the definition of movable property is broad, including the kind of property which has no real location. The state need not prove that the property was carried out of the place in which it was kept, but only that it was moved or taken from its original location, or that defendant exercised unlawful control over it, whether he was able to actually move or remove the property. The second element the state must prove beyond a reasonable doubt is that the movable property is property of another. Property of another includes property in which any person other than the defendant has an interest, which the defendant is not privileged to infringe, regardless of the fact that the defendant also has an interest in the property, and regardless of the fact that the other person might be precluded from civil recovery because the property was used in an unlawful transaction or is subject to forfeiture or as contraband. Property in the possession of the actor shall not be deemed property of another who has only a security interest therein, even if legal title is the creditor pursuant to a conditional sales contract or other security agreement. The term property of another is broadly defined to include services and intangibles, anything of value. Anything of value is defined as any direct or indirect gain or advantage to any person. The third element which the state must prove beyond a reasonable doubt is that the defendant's purpose was to deprive the other person of the movable property. For the purpose of this statute, the term deprive specifically means 1, to withhold or cause to be withheld property of another permanently, or for so extended a period as to provide a substantial portion of its economic value, or with purpose to restore only upon payment of reward or other compensation, or 2, to dispose or cause disposal of the property so as to make it unlikely that the owner will recover it. I've already defined purposely for you. It's a condition of the mind, can't be seen, and I've told you how to analyze it. If you find that the state has proven all of the three elements beyond a reasonable doubt, then you must find the defendant guilty of that charge. If you find the state has failed to prove any of those elements beyond a reasonable doubt, then you must find him not guilty of that charge. Since the value of the property, the movable property, determines the degree or severity of the crime, the state must prove its value beyond a reasonable doubt. If you find defendant guilty, then you must indicate the value of the property. The state must prove the amount or value of the property beyond a reasonable doubt. So if you find the defendant guilty of the offense, then you must decide where it fits in the amount of money beyond a reasonable doubt. You kind of heard a little bit about that today. So you're going to answer the question, and I'll show you on the verdict sheet. If it's $75,000 or more, then you would check that one off. All 12 must agree. If you don't find that, but you find it's between $500,000 and $75,000, then, and all 12 of you agree, then you would check off that number. And then we continue to go on. The third one is at least $200, but less than $500. And then the last one is just less than $200. And again, we're going to go over this on the verdict sheet. If you find that the amounts involved were taken in thefts committed pursuant to one scheme or course of conduct, the amounts may be added together to form a single total amount, whether stolen from one person or from several people. So again, you can add money together. If you find differing dates that money were taken, then you can add that money together in your overall determination of where it fits. Again, assuming that you actually found guilty of theft. If you don't find the three elements that would be guilty of theft, then we're not even talking about the amount of money that was involved. Okay. Count 14. Charges defendant with misapplication of entrusted property. The indictment reads as follows. Paul Caneiro, on or about diverse dates between January 1st, 2017 through November 19th, 2018, in or about various municipalities in the county of Monmouth, including but not limiting to the Township of Ocean and or the Township of Colts Neck, County of Monmouth, did commit the crime of misapplication of entrusted property by purposely or knowingly applying or disposing of property that was entrusted to them as a fiduciary, to wit, money valued at $78,180, belonging to Keith Caneiro and or Jennifer Caneiro and or Jesse Caneiro and or Sophia Caneiro upon agreement in a manner which they knew was unlawful or involved substantial risk of loss or detriment to the owner. The pertinent part of the statute on which the indictment is based reads as follows. A person commits a crime if he applies or disposes of property that has been entrusted to him as a fiduciary in a manner which he knows is unlawful and involves substantial risk of loss or detriment to the owner of the property or to a person for whose benefit the property was entrusted, whether or not the actor has derived a pecuniary benefit. The state must prove the following 6 elements of the crime beyond a reasonable doubt. 1. Defendant knowingly applied or disposed of property. 2. The property at issue was entrusted to defendant as a fiduciary. 3. Defendant's application or disposition of the property was unlawful. 4. Defendant's application or disposition involves substantial risk of loss or detriment to the owner of the property or to a person for whose benefit the property was entrusted. 5. Defendant knew that his conduct was unlawful. And 6. Defendant knew that his conduct involved a substantial risk of loss or detriment to the owner of the property or to the person for whose benefit the property was entrusted. The first element the state must prove beyond a reasonable doubt is that the defendant knowingly applied or disposed of property. Here the state asserts that the property was money, valued at $78,180. The term property means anything of value, even though it may be impossible to identify particular property as belonging to the victim at the time. Defendant allegedly misapplied the property because the victim's property may have been mixed with or joined with other property. Defendant must have applied or disposed of the property knowingly. I've already defined knowingly for you. I've also already told you that it's a condition of the mind and how you go about evaluating that element. The second element the state must prove beyond a reasonable doubt is that the property at issue was entrusted to defendant as a fiduciary. A fiduciary includes a trustee, guardian, executor, administrator, receiver, and any other person carrying a fiduciary function on behalf of a corporation or other organization which is itself a fiduciary. A fiduciary relationship arises between two persons when one person is under a duty to act for or give advice for the benefit of another on matters which within the scope of their relationship. The fiduciary's obligations to the dependent party include a duty of loyalty and a duty to exercise reasonable skill and care. The third element the state must prove beyond a reasonable doubt is that the defendant's application or disposition of the property was unlawful. That is, he applied or disposed of the property in a manner contrary to the responsibility as a fiduciary. In this case, the state asserts that the defendant's responsibility was to manage and administer the trust's assets in accordance with the terms of the trust agreement while acting in the best interest of the beneficiaries. As I have already explained, the state bears the burden of proving defendant's guilt beyond a reasonable doubt as to every element of the crime. The state's burden is not reduced or shifted to the defendant because he may have violated a fiduciary duty. The fiduciary duty of care is relevant to determine defendant's state of mind because it may have placed defendant on notice as to what was expected of him when he became the custodian of the property. A violation of a fiduciary duty in and of itself is insufficient as a matter of law to sustain a finding of criminal culpability. However, together with any other evidence in the case, you may consider defendant's breach of his fiduciary duty as evidence of the defendant's state of mind. The more egregious the violation, the more likely defendant acted knowingly. For example, an extended pattern of conduct displaying an utter disregard for his fiduciary duty would have more probative value than an isolated incident of bad record keeping or accounting. Fourth, the state must prove beyond a reasonable doubt that the defendant's application or disposition of the property involved substantial risk of loss or detriment to the owner of the property or to a person for whose benefit the property was entrusted. Fifth, the state must prove beyond a reasonable doubt that the defendant knew that his conduct was unlawful. I've already defined knowingly for you. Sixth, the state must prove beyond a reasonable doubt that the defendant knew that his application or disposition of the property involved a substantial risk of loss or detriment to the owner of the property or to the person for whose benefit the property was entrusted. A substantial risk is one that is of such a nature and degree that, considering the nature and purpose of defendant's conduct and the circumstances known to him, its disregard involves a gross deviation from the standard of conduct that a reasonable person would observe in the defendant's situation. In other words, the state must prove beyond a reasonable doubt that the defendant knew that it was very likely that his treatment of the property would create a risk of loss or detriment to the owner or person whose benefit the property was entrusted, and that defendant went ahead anyway, where a reasonable doubt would not. I've already defined knowingly for you. It is not necessary for the state to prove the defendant himself derived a benefit during his application or disposition of the property. If the state has proven each of the 6 elements of the crimes charged beyond a reasonable doubt, then you must find defendant guilty of misapplication of entrusted property. On the other hand, if the state has failed to prove any element beyond a reasonable doubt, then you must find him not guilty. If you find the defendant not guilty, your consideration of the misapplication of entrusted property charge should end here. However, if you found that he is guilty beyond a reasonable doubt, then you must proceed to make 2 additional factual findings. Specifically, you must indicate whether the defendant derived a benefit from his misapplication of entrusted property, and if so, the benefit he derived. First, you must determine whether the state has proven beyond a reasonable doubt that the defendant derived a benefit as a result of his misapplication of entrusted property. Benefit means a gain or advantage or anything regarded by the beneficiary as a gain or advantage, including but not limited to a pecuniary benefit or a benefit to any person or entity in excuse me, in whose welfare he is interested. Please indicate whether the state has proven that the defendant derived a benefit from his alleged misapplication beyond a reasonable doubt by marking yes or no on your verdict sheet. And then if you have determined both that the defendant is guilty of misapplication of entrusted property and indicated yes that the defendant did derive a pecuniary benefit from the misapplication, then you must go on to determine the amount of that pecuniary benefit. Specifically, you should indicate on the verdict sheet if the benefit that the defendant derived has a value of $75,000 or more, or exceeds $500 but less than $75,000, or is at least $200 but doesn't exceed $500, or is less than $200. The benefit derived includes the value of all funds or property misapplied by the defendant. That is, the value of the property misapplied is not simply the value of its use during the period in which the defendant exercised control over the property. For example, if a defendant applies or disposes of $5,000, but later reimburses the victim, the value of the benefit derived is the full $5,000. It is not merely the amount of interest that a bank might have charged for the use of the $5,000 loan during the period in which the defendant made use of the money. Similarly, if a defendant applies or disposes of $5,000 but reimburses the victim for all but $200 of the amount, the benefit derived is still $5,000, the entire amount involved. In calculating the benefit derived, you must include, but are not limited to, the amount of any tax avoided, evaded, unpaid, improperly retained, or improperly disposed of. All right, count 15 and 16. These are the last two. The defendant is charged in count 15 of the indictment with the offense of hindering his own apprehension or prosecution, in that he is alleged to have, with the purpose to hinder his own detention, apprehension, investigation, prosecution, conviction, or punishment for the crime of murder, suppressed by way of concealment or destruction any evidence of the crime which may have aided in his discovery or apprehension in the lodging of a charge against him. The indictment reads as follows. Paul Caneiro, on or about November 20, 2018, in or about the township of Colts Neck or in the township of Ocean, county of Monmouth, did commit the crime of hindering oneself by, with purpose to hinder or his own detention, apprehension, investigation, prosecution, conviction, or punishment of the crime of murder, suppressed by way of concealment or destruction any evidence of the crime which might have aided in the discovery or apprehension or the lodging of a charge against him. As to count 16, defendant is charged in count 16 of the indictment with the offense of hindering his own apprehension or prosecution, in that he alleged to have, with the purpose to hinder his own detention, apprehension, investigation, prosecution, conviction, or punishment for the crime of theft and or misapplication of entrusted property, prevented or obstructed by means of force anyone from performing an act which may aid in his discovery or apprehension or in the lodging of a charge against him. The indictment reads as follows. Paul Caneiro, on or about November 20th, 2018, in or about the township of Colts Neck, county of Monmouth, did commit the crime of hindering oneself by, with purpose to hinder his own detention, apprehension, investigation, prosecution, conviction, or punishment for the crime of theft and or misapplication of entrusted property, prevented or obstructed by means of force anyone from performing an act which might have aided in his discovery or apprehension or in the lodging of a charge against him.
This is a single
These
serving
charges
size.
are based upon a statute which provides that a person commits an offense if with the purpose to hinder his own detention, apprehension, investigation, prosecution, conviction, or punishment for an offense he suppresses by way of concealment or destruction any evidence of the crime which might aid in the discovery or apprehension of such person or in the lodging of charges against him, or prevents or obstructs by means of force anyone from performing an act which may aid in his discovery or apprehension or in the lodging of a charge against him. For you to find the defendant guilty, the state must prove each of the essential elements of the offenses beyond a reasonable doubt. Those elements are: 1, that the defendant knew that he could, might be charged with murder and or theft and or misapplication of entrusted property. 2, that the defendant suppressed by way of concealment or destruction any evidence of the crime which might have aided in the discovery or apprehension or in the lodging of a charge against him, and or prevented or obstructed by means of force anyone from performing an act which may aid in the discovery or apprehension or in the lodging of a charge against him. And 3, that the defendant acted with purpose to hinder his own detention, apprehension, investigation, prosecution, conviction, or punishment. The first element the state must prove beyond a reasonable doubt is that the defendant must have known that he could / might be charged or was liable to be charged with murder and or theft and or misapplication of entrusted property. I've already defined knowingly for you, and I've told you that it's a condition of the mind and it has to be determined based upon inferences from the defendant's conduct, words, or act. The second element the state must prove beyond a reasonable doubt is that on November 20th, 2018, that the defendant suppressed by way of concealment or destruction any evidence of the crime and or prevented or obstructed by means of force anyone from performing an act which may aid in the discovery or apprehension or in the lodging of a charge against him. The third element that the state must prove beyond a reasonable doubt is that the defendant acted with the purpose of hindering the detention, apprehension, investigation, prosecution, conviction, or punishment for murder and or theft and or misapplication of entrusted property. I've defined purposely for you. If after considering all of the evidence you conclude that the state has proven each of these elements beyond a reasonable doubt, then you must find the defendant guilty. On the other hand, if you find the state has failed to prove any of these elements beyond a reasonable doubt, then you must find him not guilty. We're very close. We're on to part 4. There is nothing different in the way a jury is to consider the proof in a criminal case from that in which all reasonable persons treat any questions depending upon... Reset that again.
You're comparing
there is nothing different in the way a jury is to consider the proof in a criminal case from that in which all reasonable persons treat any questions depending upon evidence presented to them. You are expected to use your own good common sense. Consider the evidence for only those purposes for which it has been admitted, and give it a reasonable and fair construction in light of your own knowledge of how people behave. It is the quality of the evidence, not simply the number of witnesses, that control. As I've said before, an exhibit that has not been marked into evidence cannot be given to you in the jury room, when we started 110 years ago. It may have been marked for identification. Only those items marked into evidence can be given to you. Available to you in the jury room will be the discs of audio and or video evidence. Please note that these discs may only be played in the courtroom and not by you, the jurors, in the jury room. If you as jurors want to see or hear some part of those items of evidence, you have to send out a note and let me know. Even though there's a TV in there, you're not going to be able to use that. You're going to have to come out here. We're all going to be present, and we're going to watch it with you. Very shortly, you're going to go into the jury room to start deliberations. I remind you that during deliberations,
I don't think it's use their own
and in
TV.
fact, any time that you are in the jury room, you must keep any cell phone, pager, or other communication device that you possess off. You are to apply the law as I have instructed you to the facts as you find them to be, for the purpose of arriving a fair and correct verdict. The verdict must represent the considered judgment of each juror and must be unanimous as to each charge. This means all of you must agree on guilt or innocent, or guilt or not guilty on a particular charge. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after impartial consideration of the evidence with your fellow jurors.
Or violence to your fellow jurors.
In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it was erroneous. But do not surrender your honest conviction as to the weight or effect of evidence solely because of the opinion of your fellow jurors, or for the mere purpose of returning a verdict. You are partisans. You are not partisans. You are judges of the facts. You may return to each crime charge a verdict of either not guilty or guilty. Your verdict, whatever it may be, must be unanimous, meaning all 12 deliberating jurors must agree. To assist you in reporting a verdict, you're going to have a verdict form. We can give them out right now. You had it before. We're going to give it now, and now you get to keep it. As we are giving that out right now, as brutal as that was for you to listen to me, was as brutal as it was for me to say it with my voice. Remember in the beginning when we started 110 years ago? I just gave you the law verbally. Understanding how difficult that would be for all of you to remember all of that, each one of you will have your own binder that will have the charge as I just read it to you. So you're going to have that. Now you're going to say to yourself, are you kidding me? You just made me sit here and listen to that even though I could have just read it myself? That's not the way it works, ladies and gentlemen. I have to know, Mr. Caneiro has to know, all the attorneys have to know that you actually read every single page. That's why we read it together, all together in the same room, and it's on the record. And you should listen to my charge as I told it to you. It's not going to be different from this. I may have cut some things a little short because I had already told you once or twice, but you're going to have the actual charge as that I just verbally gave to you to be able to use as a reference, to be able to go back and listen for the elements when you're talking about a particular charge. Now, you have the verdict sheet in front of you. As you can see, and we talked about counts 1 through 4 already. I'm not going to go through this entire document, but I'm going to give you a flavor so that you understand. Okay? So when you look at that document right now, it does not give you the elements of all the crimes charged. All it gives you is basically an answer key for you to log in what your answers are for a particular charge. That's the only thing that we're using it for. It will also help you and guide you to make sure you answer any and all questions that are being asked of you. We've talked about questions 1 through 4, but you'll see with each question, underneath there will be a bold, for example, to tell you, do I have to go on to a subsection, or do I go on to the next count? So, for example, as we talked about in count 1, how do you find as to count 1 of the indictment charging the defendant Paul Caneiro with the murder of Keith Caneiro? It's either guilty or not guilty. And then you see underneath, if you find him guilty, then you're to answer 1A. If you find him not guilty, then you would just go to count 2. 1A deals with doing it by his own conduct, as we talked about before. If you answer yes to 1A, then you go to B and C. If you answer no to 1A, well, then you would not answer B and C, which is exactly the bolded parts underneath. And again, it goes to 1B and C. C is located on the next, D is located on the next page. And then you see, if you've gone through question 1, A, B, C, and D, then you see underneath it says go to count 2. Same thing applies for each count. Let's go to, for a minute, let's go to count 7. 7 discusses aggravated arson. How do you find as to count 7 of the indictment charging the defendant Paul Caneiro with aggravated arson as to the structure of 15 Willowbrook Road? That is, if you answer that he's guilty of that charge, then you're not answering 7A. 7A only deals with arson. So it's the lesser included offense. If you found him not guilty of count 7, then you would go down to 7A and answer that question because you found him not guilty of aggravated arson. So then you would consider the crime of arson. Does that make sense? Yes. And that's the same for 7 and 8. Let's go to count 13 for a minute, which is on page 14 of the verdict sheet. All right. How do you find as to the theft charge? If you find him guilty, then the 13A is the amount that you find, and that should be included at that particular point. Was it more than $75,000? If not, $500, but less than $75,000, you would check there. If not that, then the third category is exceeds $200 but less than $500. You would check there, and if then none of those apply, then the last one would be is less than $200. But remember, different from murder, when I said you can agree to one form of murder of either killing and or serious bodily injury resulting in murder, it doesn't matter as long as all 12 of you agree. When it comes to this, when you're talking about those ranges, all 12 of you have to agree to the same range. It can't be one different from the other. Okay? Count 14 deals with the misapplication of entrusted property. Again, if you find him not guilty of that charge, you would not answer A and B of 14. If you find him guilty of it, then you would go down to 14A. If you say yes to 14A, then you go to 14B. But if not, if you say no, then you would not go to 14B. Then the last two charges are just guilty or not guilty. So that is the verdict sheet. Now, if during your deliberations you have a question or you feel that you need further assistance or instructions from me or wish to have certain testimony read or played back, which is either audio or video. Remember in the beginning when we started 110 years ago? You don't have. Write your question or request on a sheet of paper and give it to the sheriff's officer who will be standing at the jury room door, who in turn will give it to me. The court officer will be sworn to perform certain duties, such as keeping the jury together in a private place for purposes of deliberations and ensuring that no one speaks with you except by order of the court. You are not to discuss with or ask the officer about any trial matters or procedures. Please be aware the officer is also instructed not to initiate communications with you or enter the deliberation room without your consent, except to communicate on behalf of administrative matters such as breaks, meals, the end of the day, telling you that you're going to go home, come back the next day. If an officer must enter the deliberation room, the officer will knock first, and once he's done with completing whatever he was asked to do by me, then he would leave the room, and then you could start your deliberations again. But do not deliberate when he is in the room, he or she is in the room. Once I receive your question or request, I'll go over it with the lawyers, and I'll get you an answer as soon as possible. Please be patient. If we have to get something electronically, you got to give us a minute to put it together so we can put it on the screen so you can come out and see it. Please, if you're in the middle of a debate on a particular issue, do not tell me that you are, Judge, we're 6-6, we're 10-2 on this issue. Can you just help us out a little bit? I don't want to know where you are in your process. The only thing I need to know is either you got a question and I'm going to answer it for you, or you got a verdict and then we know it's unanimous. That's the only time. Okay. Now I've come to the end of my charge. Let me just speak to the attorneys for a second. I'm going to take a second.
Yeah. He said it would just take a little bit to read the instructions. 2 hours later, we're still here. Jury's looking at the clock, thinking it's time to go home, and we haven't sent them off to deliberate yet. They still don't have a form. We don't even know which ones are going to go home as extras yet. The alternates. All that needs to be selected. So I think we're going to wrap up the day. I don't know who suggested the Colonel Sanders' favorite jelly beans. Those look delicious. Where do you get them? Where do you get the KFC jelly beans? I'd like me a big
Remember in the beginning when we started 110 years ago?
You guys are getting a little sloppy with the commands, playing them all during the judge talking and stuff. Can you buy them at KFC?
You're comparing apples and orangutans here.
I'm doing that, yes.
Hush! Now I'm trying to have court. You don't raise your voice again.
Don't miss the forest for the trees.
Okay. I think.
Are we going to address subject matter jurisdiction?
Even a blind squirrel finds a nut every once in a while.
Hello?
I think I'm about to catch a whooping.
Because he's the guy.
There we go. Greeners, I tried to update the commands list. I'm not sure if it worked or not. Because of character limitations.
No. Hello?
Because of character limitations, it might
I don't like podiums, Your Honor.
need to, yeah, you have to ask it twice.
This is not Burger King. People do not get to have it their way.
Remember in the beginning when we started 110 years ago?
There we go. They're now alphabetically sorted. Thank you, graders, for that.
I got a stubby
and
pencil.
Thank you, Amber, as well. Amber's been trying to get me to work on these sounds and fix things on the channel, probably for the last 2 years.
I object.
Greeners shows up and I start fixing things. And Red Pen.
I'm not going to argue about semantics.
Mighty persuasive as well. So, KFC jelly beans have a bad aftertaste.
You don't put a diplomatic plate on a hoopty.
I'm not a camel.
I am not able to change
Somebody
emojis.
just sent me a video of roaches fighting. I don't know who won.
There was a time on the channel, probably during the Cavalcante manhunt, where we had 2,200 members on the channel. These are
It's bigger than you. It's bigger than me.
These are people that show up
It's
in
bigger
green.
than all of us.
Never, ever again have we ever had that number anywhere close to that.
Talking to cats.
But I built all my emojis when we had that many, so I got YouTube gives me emoji access based on how many members I have. So I built them all.
The start of the apocalypse
And when I
may
try
be
to change
upon
them,
us.
they say, "Oh, you're under the threshold. You don't have access to that anymore." So I really can't do much to the emojis until we're massive. I just can't do anything.
You're comparing apples and orangutans here.
I bought my emojis. Okay, here we go. Listen. I'm going to send you home.
Moment of truth.
Hush!
Couple
We
of
have
alternates.
our,
Raise your
way
voice.
that we
Turn them off.
do our alternates. So bring that in.
Turning off the sound bites. You guys can't be good.
No, you're good. We know where you are. Get ready.
Knew it.
Approve. Person showing at the end of this is, I want absolutely no responsibility at all. Relates to this. So what Anna's doing is, so that you're aware,
Get your
is
bingo
that
cards.
it just says juror 1 through 16 on some cards, and what we'll do is we spin it, we put our hand in there, and we come up with one. 2026, we're in.
Works.
Don't fix it if it ain't broken.
We have just run a special.
Okay, go ahead.
There's a handle on the other side. Can't look in. Can't look in, ma'am. That's cheating.
Juror number 16.
Juror's number 16. Okay, keep going.
Let's see if number 9. You're spinning it too fast. The centrifugal force is keeping the cards. It's 15, 14, and 13. Place your bets right now. What you can draw. I'm saying 9 is out.
Juror number 15.
15.
Okay. I was joking about the 15, 14, 13.
Spins well.
That's what the juror just said. They pull 14, that thing's messed up.
11.
Ooh, it's working. Good, good, good.
Okay, one more.
Let's do a little dance. Here goes number 9.
8.
Oh, so close.
Okay. Okay. So jurors number 8, 11, 15, and 16 will be my alternates. So right now, just hang out for a second, and we'll talk about that role in a minute. What I want to do is right now is I'm going to swear in my officers. If there's new officers tomorrow morning, then I'll swear in new officers. But I'm going to ask for the officer in the back and also the officer in the front. If you don't mind, could you just raise your right hand for me? Do you solemnly swear or affirm that you will do your best to keep every person sworn on this jury together in a private place, and that you will not allow any person to speak to them nor speak to them yourself except by order of the court, and except to ask them if they have agreed on a verdict until they have so agreed?
I did.
Thank you. All right. All right, so next part. I want to give you an idea for the people that will be in the jury room for a minute. I just want to tell you the items that you will have, because you won't have certain items in there. For example, we don't give you the guns in there, or we don't give you the bullets in there, and we definitely don't give you both of them at the same time. So
because we know how deliberations
if you want
go.
to see the weapons, any one of the weapons involved, you would have to ask me. You have to write a note saying, can we see S whatever? And then we'll give it to you. And if you don't know the S number, we'll take care of it. So let me just tell you what you do have in evidence. S1, which was the photo book with all its subsections, you have that. You will have...
You're not going to name every single item, are you? Seriously?
S2.1.
No!
Which is a photo from the Caneiro family. You'll have S7. I'm not going to read them all. I guess I have to. Text messages that you'll have from November 20th, 2018. S8. Well, if you're going to physically have them, I don't think I have to read every one.
Thank
You'll
you.
have S8,
Oh my goodness.
S10, S11, S12. These are all records, so you'll physically have all of them. S17, 18, 19, 26, 28, 29.1 through 29.10, 30.1 through 30.19, 33.1, 34.1, 35.1, 40, A and B, 42, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 61, A and B, 62, 63, 64, 65, 66, A and B, 74, A, B, C, D, and D.1. Now, did 70, I should go back. So 66 is the Waze camera from the kitchen area and the office area. You'll have a disc of that. If you want to see it, you got to come in here and we got to watch it. 74, which is the body-worn camera of Patrolman Marino. If you want that, you got to let us know. It's in evidence. We'll bring you out here to play it. S76, A, B, C, and D. That's the Patrolman Wankowski's body-worn camera. Again, if you want to see it, come on out. 78, same thing. Patrolman Bernard's body-worn camera. Come on out and we'll show it to you. Then you'll have S93, S94. S96 is the 911 call from Boris. That's 96B. 99 is the CD of Catherine Lucchese's 911 call. 101 is the DVD of the sergeant from Colts Neck, his MVR. If you want to see that, you can come out. We can bring you out. 102, same thing. It's Patrolman Stephen the Caesar's Colts Neck, his MVR, and if you want to see the gas can at S155, we're not going to put a gas can in there. If you need it, well, we can give it to you.
Keep going.
You okay?
Yeah.
Okay, we're almost there.
Good. Liquid adjustments.
The gas can. Then you'll have
liquid adjustments.
156, 157, 158, 159, 160, 162. It's the automatic knife. You saw that. If you need to see that, you have to tell us. We'll come out here and you can look at it. Same thing. Well, you'll have 163, 164, 166, 165. You'll have 168, 169, 170, 171. You'll have 172. You'll have 173. 174, 175 you'll have. Then we get into firearms. You will not have, but you could see it if you want to see it, is the 9mm. Well, you'll have the barrel. That's 176. 177 is firearm parts. You will not have it. If you want to see it, you can let me know. 178. Is the Pelican Storm case with a knife and flashlight. If you need that, you can ask me. 179 is a magazine. Also, you won't have that. 180, 181, again, that's any guns you won't have. 183, 184, 185, 186, you'll have those. 187 is also a handgun. 188 is a handgun. You won't have these. 189, you won't have them, but they're in evidence. 190, 191, 192, 193, 194 is ammo, the Fiocchi ammo. If you want to see that, all you have to do is tell us. 195, 196. Again, if you want to see those things, all you got to do is ask. You'll have 214. 222 is the 6 magazines and 11 unfinished lowers. If you want that, you're going to have to ask us for...
The jury's saying all we need is a verdict form, Judge.
You'll have 231, you'll have 232, 33, 234, all the way up to 242. You'll have all of those. 256 is the 911 call from Dennis Kapora. If you want to hear that, you got to come out and ask us for it. You'll have 261, 262, 263 is the DVD of vehicle surveillance videos. If you want to see any of the alleged car leaving the Tilton address, and then any of the videos at Colt's Neck, you're going to have to ask us for it. You'll have 264, 270, 270.1, and again, more surveillance cameras. If you want them, you got to ask for it. You'll have emails from 273, 274, which is the iCloud emails that were read to you. You'll have those. You'll have scene diagrams in 285.
Tumwater Troy, thank you very much. Sloth Life, thank you as well.
Items from the autopsy. You'll have all those. That's $299. Through $329. You'll have $338. 347, this is text messages between Block and Paul Caneiro. You have 375, which is a Verizon lost power notification. 391 is the ways of the garage north shelf. If you want to see that, you'll have to come out and ask us for it. Phone calls, the 3 phone calls were played. They're in evidence. 392, A, B, and H. If you want to hear those again, you have to come out so we can play them. Generator 405, photo depicting the electronic panel. Those are in evidence. You'll have those.
Thank you, I Rescue
Any
Dogs.
photos you're going to have, which is 418, 419, 437, 467, 474. You'll have all those. You'll have photos from the defense. They have a bunch of photos that they're going to give you also. That's marked D1. And there's a large number of photos that you're going to have in your possession. You're also going to have...
Josh honors something you said in mod chat.
Text
Comes through
between
at 10.
Ben, Keith, and Paul.
10
D55,
gifted memberships. Thank
the
you,
Canada
Josh.
Life full payment breakdown, D64.
Thank you, I Rescue Dogs.
Body worn
Sloth
camera
Life
again
as
from
well.
Marino. If you want that, we'll have to bring it out so you can see it. Marino, that's D71. A photo of the refrigerator. You'll have body worn camera again of Redmond. You'll have to
Ivan,
come
how
out
did I
for
miss
that.
this?
That's
How did I miss this one? Thanks,
D106. Video of 44 Willowbrook at 8 p.m. That's D114 if you want to see that. We'll bring it out. D122 is an email between Paul and Sense. You'll have that.
Susie, you are an OG.
D140, 141 are allele charts from Bodie. You'll have those. You'll have certain PowerPoint slides from Carl Reich, pages 2, 10, 11, 12, and 13, not the entire PowerPoint. But you'll have those pictures, and you'll have those in your possession. So I only try to tell you that because so that you have an idea of what you do have. I can't give you the list because the lists also have things on it that you don't have. So I apologize that I can't just give you that. Okay, so now here's what's going to happen. It's now 4:30. So now you're going to say to me, really? We just done all this and now we got to go home? We don't keep you overnight for when you start deliberations. We normally finish the day somewhere between 4:30 and 5. But because it's been an extremely long day for all of you and a ton of information, and out of respect for all of you guys now, what I'm going to do is I'm going to send you home for the day. However, this is how it's going to work tomorrow morning. Tomorrow morning, as soon as all 12 deliberating jurors are here. If it's 8:02 and you're all here, Amor is going to bring you up. She's going to put you in that room. In that deliberation room will be all of the evidence that we just discussed. So you're going to go in there and you get started. There's no more wait. In that room will also be 12 binders that will have all of the charges laid out for you. So you'll have your verdict sheet, you'll have your binder. It'll all be in one little binder for you, so everybody can open them up and talk together as a team to figure it out. And you'll get started. My 4 deliberating jurors, you will be taken to another room very close to this room.
Oh,
why do I do that? I'm not going to leave you downstairs. Here's why. If something happens to one of our 12, we take the 4 numbers, and when we bring you back, and we then put it right through this lovely machine again, we pick one out of the 4,
it's a contraption.
Random, and then that one would go in to replace one of the 12 that couldn't continue. But we need 12 to be able to decide. Understand, if you're not, for example, if someone doesn't come in tomorrow or whatever that is, then, for example, if you're one of the 12 deliberating jurors, I'm replacing you at this point. And we're not, at this point in time, we don't slow down. Here's what I'll tell you.
At this
Tomorrow,
point, we don't.
You have as much time as you need. You have all day if you want it. Probably, if for some reason at 5 o'clock or so tomorrow, if we're not done, fine, no problem. What I do is I bring you back on Tuesday. I don't bring you back Monday because Monday's the holiday. So I don't want you to stress about time. You have as much time as you need to be able to do whatever that you need to do. So with that being said, though, you have everything, but you can't start yet. Tomorrow morning, you'll start first thing, and you go as long as that you need. So thank you. It was a long day. It's a long 2 days for you all. And I'm beyond thankful. And I'm watching you, and you guys have been wonderful. Probably the best jury that I've seen, and I've been doing this for a long time. So I'm beyond thankful for everything that you've done, your attentiveness, and we'll get this going tomorrow morning. So we'll bring you downstairs. You're gone for the day. Leave your verdict sheets exactly where they are. We'll take care of that. We'll pick them up from you. You don't have to try to do anything with that. We'll get you out of here, and then we'll see you tomorrow morning. So as soon as we have all 12, we're bringing you up. You will not see any of the attorneys tomorrow morning. You will not see the defendant tomorrow morning. Then at this point in time, it's all about you. If you're in the room, you do your thing. The only time you're seeing any one of us is that if, for some reason, you have a question or if you have a verdict. Okay? All right. Thank you all.
Judge, very quickly, just approach.
Let me approach very quickly.
If
Misconduct.
anybody has to go in there, go ahead, just in case you have to use the bathroom or something.
Misconduct, you are an OG, 34 months. Thank you very much. Donna Turner, we're addicted to your Recovery Addict because over 1,000 are still here with you after this crazy trial. We just can't imagine it getting any worse. And then it just keeps, this is for you, Red Pen, getting worser and worser. It's terrible. I'm sorry, Red, that was uncalled for. Yeah, it's bad. It's bad. Deliberations start tomorrow. We're on verdict watch. The jury will not be brought back again into this room. They will start deliberating between when they leave this room and when we see them again. Amber says I'm going on strike. Amber, thank you. You're amazing. Hope everything's going well for you. What are the odds that one of the alternates is like, better get this guy on the way out the door?
Sorry to you, because I forgot to bring this up in front of everyone. So, when the verdict, if a verdict comes in, because you're seated in juror number 1 seat, I would like to make you the foreman. Your vote has no more power or less power than anyone else. Maybe you would start the deliberation process tomorrow morning. But my question to you is, would you feel comfortable as the foreman as to when the verdict is read, if you do reach a verdict in this case, would you be able to do that for us?
Yes.
Okay. Any issue? You comfortable?
No.
Okay. Okay. Great. You will then be our foreman. All right. Thank you, sir.
Juror number 1
As
in
soon
the
as
hot
they're
seat.
ready, everybody can start to go.
Juror number 9 has been vouching for that job, trying to butter up the judge, and lost out.
Everything gotta be marked by hand and evidence. So you should start here. I'll go get the other stuff.
Okay.
For the record, we're giving you the updated charge that cleans up the issues that we had.
We are not starting the verdict watch, even though the jury is walking out of the room with all the instructions and all the evidence, apparently. They're just told to collect their eggs and go home. Nine was the winter liker.
Ask for you to work with the attorneys to
And
change the markings on the
bailiff
labels,
talker.
so it says EB on it. Okay.
You want that done tonight?
Yeah, because everything has to be done in the room, and then the sheriff's department, we have to lock it. We have to put a note on the door that says no one to come in, no cleaning people, no nothing from now on.
Big note. Do not clean up this room. What looks like trash to you is evidence in the murder trial. Janitors not allowed.
Need to change the books and stuff. Go ahead, you guys can get
I
started.
did it already.
Already done?
Yeah.
So why don't you can collect those sheets and you guys can start putting them in there. So as soon as they walk out, you can put them, once you're done.
This trial has been a little bit of a slog, as you say, Sun Bunny. I agree with you there. But we did get a couple sound bites from it. And we did have some spicy action, at least one day. Ivan, what happened? Oh, I see what happened, Ivan. I got it. I checked it out. Good work, Amber. Or whoever it was. Sorry. Ivan, if I'd seen that, I'd time it up myself. So I can go back in time and see what happened. It's one of the tools I have at my disposal. I can see the deleted messages. Ivan, I'm just going to say I don't want to see any bands' album covers or inserts. So that's all. He just suggested a band's name, and that's all. All right. Okay, now we're done. I can't share it. It was bad. It was naughty. It was naughty. All right, with that, we are done for the day. Everyone is going home. We're going to be back tomorrow morning. 8 o'clock. We'll start the timer. So we are planning on trying to watch the au pair sentencing tomorrow. I hate doing court hopping on a Friday because a lot of courts just do landlord-tenant stuff, but we'll be looking for that. Obviously, we'll probably get some Thurston, Washington action, maybe something out of Judge Boyd's court.
Call from
AWOL.
AWOL, how's it going, my friend?
I'm calling to apologize.
For which one?
For this whole case. I brought this up to your attention, and you said, I don't know what it is. I'll look into it. Then I asked again, and you said, oh, I looked at it, and there's some facts that I don't know if I want to cover it for the channel because you know what I'm talking about.
Yep.
Yet here we are, and I go, oh, no.
Oh, I counted this in your record. I put this in my notes. AWOL recommends bad trials is what that's like abbreviated. It was more verbose in my write-up of you, but
I guess because I'm from Jersey and it was an NJ trial, I figured let's just, watch one from NJ, but
I've got to ask
never again.
Why?
Oh my God.
Like, most of the other people on trial for murder had their trials start and finish and were sentenced while we were just listening to closings. This took forever.
Right.
Is that a New
which
Jersey
I
thing?
posted it. No, I posted in chat and I did some research. Some might think, and I read some chats, some might think that New Jersey has a no limit for closings. That's not true. Any judge can put a limit on closings. If he feels that the evidence was so crazy, he would go, you do whatever you want. Right? But this judge, like you said, might like the camera. So he said, everybody have their whatever.
What gives
do
you that
whatever you want to
impression?
do. You said it. I didn't see it.
Yes. This guy has
it's
no
a
hurry in his body. He just takes his sweet time, and honestly, he reads well. I mean, we've had judges that read poorly. He reads well. I'll give him that. He's very good at it. He's very thorough. But I would really like to know what the jurors' faces looked like. Like, how many of them rolled their eyes like, oh my goodness, he's reading the instruction about experts again for the fourth witness today.
Right, and I would like to see another I would like to see a different trial with a different judge, because his jokes coming back from breaks, when you look at certain, like the judge in the Meyer case, he was so professional. I don't think he would have done half of this. He was so professional. He didn't pick a side.
And
he got hot that one time, but he came back. Okay, I'm sorry.
Sorry, I'm trying to. Please stop talking while I'm interrupting.
No, I'm sorry. It's your channel. You're the captain.
I was going to say, there are people who would be offended at a judge that makes lighthearted jokes in a murder trial, saying, how is that respectful to the victims, or how is that respectful to the defendant? You know, how can you be up there just like, elbow, John up with the jury when literally somebody's life is on the line? I think there's a time and a place. It's a fine line. It's a delicate line.
Correct.
And people view it differently. I appreciate it. It's sort of a little bit like police humor. You know, they've got officers generally have a darker sense of humor. They'll joke about things that other people might think, whoa, you went there. But
yeah, they become desensitized to it all.
I like it.
It's just, and I don't know. It was a little too much for me when it comes to the fact that he sits high. There's a reason why the judge sits higher than, physically sits higher than everyone in the courtroom, because he's supposed to be honorable. We're supposed to look up to the law, which is the oath that he took and what he represents. I think that oath and that burden and his job and his task comes with a level of neutrality that one should follow that through the whole trial. Now, when it comes to sentencing, and after the jury made the decision, and after that fact, he can now elaborate on his own opinion and say, I think you're a monster, you caused this family harm. That's the time where the judge, I think, should say what he wants to say. But during the trial, you can't say, while the defense is doing closings, you have been here for an hour, I think you need a break. He never once said during the state's closing, you have been here for an hour, I think you need a break. It's just little things like that I pick up on that I don't think it's fair. Again, the judge in Maya's case would not have done that.
Judge Carroll was amazing.
Judge
Carroll has the mind like a trap.
Amazing.
He recalls what was said verbally in argument at the bench at a hearing 6 months before this. Well, I'm sorry to do this. I've got a spam call. You know the rules,
right? Take it.
Okay, all right. Thanks,
yeah. Go ahead.
Love you, man. See you.
Love you all. Love you, chat. Bye.
Hello? 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 Are you there? They hung up. You knew they were there. You could hear them. I was too eager. I'm sorry, AWOL. Great comments, though. Let's see. Anything else we need to do? He just said something today during state closing. We have a podcast tonight. I probably haven't mentioned that enough. Hold, please. Let me just make sure. Let me take a quick peek at the rundown to see if there's. I can give you a little sneak inside peek at what's coming up. Let's see. We're in February. It is the 12th. Thomas is amazing, by the way. Ooh. Food is going to be on the menu for sure. Some potty humor. It's going to be there. You know that's going to happen. Oh my goodness. Okay. This tonight, let me just say this. Tonight might not be the night to invite the kids to the show. I mean, we're still a family friendly channel, but the content might require explaining afterwards. And if you want to know exactly what type of explaining or what that entails, you're going to have to be here tonight at the podcast, for the Not Relevant podcast, right here on this channel, 8 p.m. It's going to be good. I'm already seeing it. Oh, Thomas is in there right now as we speak, working on the rundown. It's going to be good. Just came back. What's happening in court? Well, they sent the jury home. They'll start deliberating first thing tomorrow. This will be RA After Dark. It'll be different. We've got a couple stories you can sort of string together content-wise that might be interesting. I'm in a jet lag. What time is it there? Right now it is 4:50. Well, almost 4:50. So just shy of 5 o'clock. And so we're going to be going live in 3 hours here. The podcast will be heavily redacted. Ivan blurs the lines once again. Ivan, thank you, my friend. Appreciate you being here. All right. Thank you all. Thanks to our amazing mods who it's actually hard work. When we collectively are just not happy with what's going on the screen. Chat can be a lot of work, and the mods handled it phenomenally. Interjected just the right amount of humor, interacting with people. Amazing. Creepers got shit. All right. Thank you all of you, and I appreciate all of you for being here and being generous. Oh my goodness, the gifted memberships are incredible. Your super chats make it all possible. Thank you. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. And please stay safe till we go live again 8 p.m. tonight with the Not Relevant podcast. I'm so happy I can delete this pinned message that jury instructions are going on. They're over. I will give you the results to the poll before we leave, though. How long do you think the jury will deliberate? Of course, this timer is going to start tomorrow. And it says, let's see, 6 to 8 hours, which might also include over 8 hours. It's 36% of you. 4 to 6 hours, 30%. 2 to 4 hours, 25%. And 2 hours, just 9%. That's the first time the results have come in, all favoring the highest time as the winning time. Usually we come in on the low side, but this court has been a little bit different. How about your new mod? Do we get to keep him? Greeners, are you willing to hang out and be a mod for us? I should have asked you. I never have. Greeners, will you be a mod for us? Maybe? Silence is golden. I don't know. Greeners, are you there? I'm citing a 5-year, 10 minutes ago. It sounds like it's a deal. It sounds like he's made a deal with anybody. Anyway, so thank you all. Have a good night. We're going to see you tomorrow. Well, tonight, the podcast. Bye, everybody.
You're talking about stuff that is not relevant.
Ivan, I just saw what you did.
Remember in the beginning when we started 110 years ago?
There's nothing in the order that restrains you from talking to cats.
Thank you.
It's bigger than you. It's bigger than me. It's bigger than all of us.
I think I'm about to catch a whooping.
You don't put a diplomatic plate on a hoopty.
Remember in the beginning when we started 110 years ago?
You're comparing apples and orangutans here.
And now let Murdoch stole it.
I'm not going to argue about semantics here.
Because he's the guy.
I'm going to sustain my own objection.
Oh boy.
There's a
Oh boy.
canine.